My lord, restoration application.
Upon notice?
Upon notice.
My lord, under extremely compelling circumstances, I beg to mention one writ petition, my lord. Here, a luxury bus was seized and confiscated without due process of law. And my lord knows these buses are extremely expensive, and the bus is decaying day by day. If your lordship kindly allow.
Please wait for some time.
Under compelling circumstances, may I mention a matter?
It's not being allowed for the time being, sir. Please wait for some time. Only restoration applications and corrections, contempt matters, nothing else.
We don't want application for appropriate orders.
We have to wait for some time, please.
Actually, my lord, in connection with a disputed land, during the pendency, they are trying to dispossess me. I want some protection in between. That is the urgency. Under right to fair compensation act, I made an application for return of the land. That is pending. 10 years have passed. They did not take possession.
It's vested. You cannot ask for a divestment.
No, it is. The rule is
and
after vesting
2013 Act, you are admitting it to be acquired land.
Yes, but if it is not utilized within 5 years, then you are entitled to return. I made.
Wait for some time. It's not that.
Madam, item number 27 of your lordship's list, madam. This is an unauthorized construction on a.
Item 2.
Item 2 is my
application.
This is my application for recalling of your lordship's order. Because of the ground, your lordship kindly have a look to page 9 your lordship's order. This order was made upon direction to the respondent of 3, page 9. At the instance of the submission made by the respondent, your lordship please to direct this matter to consider by the Deputy Director, Refugee Department. That time I was opposing, but since they are relying on that point, I have accepted. But now they have written the note that there is no such post. Earlier it was such post, so that representation to be returned.
So it has to be before?
Before the director.
Have you served?
Madam.
Who is appearing for the respondents?
Mr.
Bandopadhyay and Mr. Bottogal. Where are they?
Soumitra, I have given the notice upon the day.
So they is not appearing in this matter at all. How can you give a notice to Mr. Dev? Mr. Bandopadhyay and Mr. Bottogal are appearing in this matter.
Then I have to give.
Please serve and come back. Thanks. So Mr. Bottogal is here.
You have not served the copy. You have not served the copy of the.
By today, I shall serve it.
Not today?
Not today.
Please serve immediately.
Even they are not even have the copy of the notice also, but they are included in the list without notice.
Well, that notice, my impression is that the Mr. Dey is representing the state.
How can you have such an impression, sir? The name of his name is recorded.
In the notice, I have named there. First, I have named Mr. Dey. Thereafter, or assumption.
You cannot do that, isn't it?
That is my mistake.
I mentioned. Yes. Next.
Phone number 10.
My affidavit in opposition, my lord, is in the course of affirmation. Could it be a very short passover? Because, my lord, the
passover not possible.
My lord, you will give me that, my lord. I will. Your lordship can fix another date.
But may I hand him over the copy of the, my lord, oppositions?
Your lordship can fix another date.
But in course of the day, may I? The review application, I am filing the opposition to the review application.
Learned counsel for the petitioner, seeking extension of time to affidavit in opposition.
May I file it in course of today? I'll file it in course of today. It's in the course of affirmation.
You want it? I shall come back next first week of April.
First week of April.
4th April?
4th April.
Let the matter appear under the same heading on 4th April.
But I'll serve him a copy, my email.
Item 5.
We beg to appear on behalf of the Milord alleged contempt, and your lordship's order has been complied with, Milord.
Affidavit of compliance.
Milord, order has been passed.
Compliant, madam. I annex my lord order. Kindly see, my
Milord,
lord.
we have passed an order. If he is agreed, we can file a fresh writ
My lord,
application.
kindly see, my lord, what is the order, my lord?
Milord, kindly go.
22.
Where is your affidavit of compliance?
Milord, it is not that case, Milord, after your lordship, Milord, after this period, Milord, period has been elapsed, thereafter we have complied. It is not that, Milord, we have complied, you have passed an order,
Is an affidavit showing that you have complied with the order?
Milord, that has been annexed by the contemptor, Milord.
Annex, my lord, but all order is not contemptuous, my lord. By violation of the honorable court's order. That is my.
Page 20,
Contempt application.
page 28 of the contempt
Yes, ma'am.
application.
Plus six. Kindly see, my lord.
Milord,
Last
this is
para.
the reasoned order, Milord.
Last para, my lord, kindly see. After heard all the parties
What order to cause?
and submitted documents and as per the road boundary demarcation report of the BLN Harwa by memo number so and so,
Milord, kindly, your lordship considers your lordship's order, Milord. Operative part is, Milord, is at page 22.
28 is the order.
28 is the order, our order, Milord, and your lordship's order is at page two. Yes, 28, Milord, and an ultimate paragraph, your lordship kindly sees. Encroachment, you know.
Yes, so the order has been complied.
my lord, order of, kindly see my lord, order. What was the order, my lord? Kindly see page 22. Kindly, operative part, my lord.
Page
Second
20.
paragraph.
Page 22.
Yes,
Second paragraph, my lord.
yes.
In the premises, the court is inclined to hold that since demarcation of the disputed plot in question is in process, in the event encroachment upon the PW land or any portion thereof is found upon demarcation, the assistant engineer is directed to initiate proceeding under section 10 of the West Bengal Highways Act.
Yes.
My lord, it is found that that portion has been, my lord, encroached.
By the government authority.
But my lord, permission is necessary.
জজ আমাদের সঙ্গে আছে
Private
তারপরে বলো।
individual. Your case was that some private
Sorry.
persons are encroaching.
But my lord,
That
that
was
is
your case,
panchayat.
isn't it?
Panchayat, my lord.
Panchayat is not a private person. It is an
But my lord,
instrumentality of the government.
but my lord, West Bengal Highways Act, my lord, permission is necessary.
If you are aggrieved by this order, you have a separate cause of action.
Lordship.
This is a contempt application.
My lord, yes, my
So
lord.
this has been
But my
complied.
lord, specific direction, my lord, to initiate proceeding if my lord enforcement is there.
That's already
ছেড়ে
there.
দেবে জজ তো আমাদের সঙ্গে আছে।
By any private individual. So there is no question of initiation of proceeding. It has been complied with.
Which is the
Heard learned counsel
Which is-
for the parties.
extremely
It
grateful.
that the order under contempt has been complied with by the alleged contemptor. Paragraph in view of the above, the contempt application being CPN such and such is disposed of. Paragraph, there shall however be no redress to costs. It's a separate cause of
My lord,
action if
yes, ma'am.
you're agreed.
Your contempt proceeding is dropped.
Item 6.
Extremely grateful, madam.
Yes, who is appearing?
I am appealing for the petitioner. Item
Sir,
6.
I was the alleged contender, madam. I have
There is
communicated.
an affidavit of service.
Lordship.
When I am paying 1 month time because my lord, I have already communicated to the BLN to demarcate the land in question. Unless the land in question is demarcated, how I will vacate the land?
Lordship, for a moment, Lordship, kindly see that order has been passed before 9 months ago almost.
Yes.
And
16
they-
June.
They have done nothing. Respondent number 3, that is assistant engineer PWD, they have done nothing.
And in
They have not given any notice under section 10 according to Lordship's order. And for a
demarcation has not been done. That is his submission.
Well, after 9 months, after receiving contempt
There was a
application with
direction
contempt
report
notice.
for the demarcation in June 2023.
Lordship,
Where is the demarcation report?
Lordship.
Well, the problem is, well, we put in through the PLLRO, we put in through to every department concerned, also special land reforms officer. The map is not there with the PLLRO. We
The
wrote,
concern of this court at all.
I understand them. So we told them at least 8 times we have given them letters that unless you demarcate, how can I demolish? Because some part of the land, some part of the construction might be in private land. But we will have start getting cases.
No private land, only PWD
Then
land.
let us say that there is no private land, let us give an affidavit to that extent, we'll go and break it.
Lordship,
The direction for demarcation way back in June 2023.
Exactly, my lord. I have no
March,
defense to
9
tell your
months.
lordship that why it has not been done. But I can show to your lordship, demonstrate that we have given at least 10 letters, 15 times we have gone to them, even to Nabanno, to get the acquisition plan and
PLLR is subordinate to the assistant engineer, I believe.
no, it's a separate department altogether. They are
I'll
absolutely
give you 1 month more time, otherwise I'll issue rule.
my lord, 1.5 months is sought to demarcate.
I don't know. Demarcation should be within 10 days.
and Lordship, for a moment, Lordship, kindly come of your Lordship's order, page number 21.
I've seen the order.
Where it has been clearly stated, your Lordship's order, that the police authority has already been stated that the that passage adjoining the petitioner's property is fully occupied by the OP numbers.
Yes.
Lordship,
It is an admitted case and you still.
Lordship, I'm ready.
My lord, we can do it.
I suspect this is for extraneous considerations.
Malad, my communications here, I spoke to the executive engineer personally on the issue. But why for more than a year, nearly a year, this has not been done? He is saying that I can do it because the High Court has ordered, I'm duty bound to do it. The problem starts is that there's no demarcation of the land. And without demarcation, if I do it, and tomorrow there are many
I
things.
will not hear all this story at all.
Lordship,
I'll grant you 1 month's time to comply with the order in its entirety. Otherwise, your authority comes and stands before the court. I'll issue a
Lordship,
rule.
I'm grateful, Lordship.
Malad, in that
Then
case,
you
Malad,
can't
may I
say
seek
that
for,
come back.
Malad, may I seek for indulgence? Malad, I am not defending anybody. I am not defending a cause. When a High Court passes an order, it has to be done in letter and spirit, Malad. I cannot defend this.
9 months' time, nothing has happened.
Yes, I cannot defend, but this is the cause, Malad. Kindly grant me 1.5 months so
Not
that
at
I can
all, not
complete.
at all.
No,
1
45
month and
days.
you're, Not at all. Affidavit of service. It is most unfortunate to note that the order under contempt has not been complied with as yet. Paragraph, let the matter appear under the same heading on 15th April 2024. Paragraph. Affidavit of compliance be submitted on the adjourned date.
Well, this is the reason your lordship might kindly recall on day before yesterday. I request your lordship to pass the order in also against the PLLRO. Because this is the exact thing that I'm facing here. I would have faced in the next week. That's why in the 2 days prior to this, I request your lordship to pass an order also on the PLLRO to do it. Now they don't have an order on the backs. I'm having their gunning. I'll be taken to task, my lord. PLLRO will not do anything. That is the reason when the orders are passed, my lord, they should also ask that the PLLRO should also be a party and the order should be against them too.
Was a party, I think.
But the order was not passed. It was only direction on the executive engineer. I'm ready.
Next.
I'm grateful.
Lordship, appearing on behalf of the petitioner. Lordship, according to your Lordship's order, the respondent authorities complied.
Complied with the.
Yes, Lordship.
Who is appearing for the?
Lordship, I am appearing for the state respondent.
Comply?
Compliant, Lordship.
Is submitted on behalf of
Welcome there.
both the
Welcome
parties
there.
that the order under contempt has been
Welcome.
complied with. Paragraph in view of the above, the contempt application being CPN such is disposed of. Paragraph, there shall be no orders to costs as a report.
And also finding the compliance report, Your Lordship.
Actually, the compliance report should have been on the, by way of an affidavit.
Lordship.
You've not sworn an affidavit to the effect.
Affidavit.
Should have been by way of an affidavit.
Not on affidavit, Your Lordship.
Formal report.
It's a formal report. Your
Compliance
to
report submitted on behalf of the alleged contender is taken under. Next,
Dispose of, Lordship.
dispose of.
My lord, I am for the petitioner, my lord.
Yes.
My lord, I am for the petitioner, my lord, led by Mr. Rajdeep Roy. My lord, he is bedridden, my lord. Kindly grant me some adjournment.
Earlier occasion, he has taken the time.
But still
I
he is
filed the
bedridden.
report, did not file the exception.
You handed over copy in the court.
Yes, oh yeah.
On prayer of the petitioners, the matter is adjourned. Paragraph, let the matter appear under the same heading on 16th April. Lordship. Great.
এতটা সময় নিচ্ছে।
Item 9.
But I beg to appear for the petitioner.
My lord,
I am led by Mr. Chatterjee. He is appearing through virtually.
My lord, I beg to appear for the petitioner, my lord. I'm sorry, my lord, I could not
Yes.
appear today. But I'm for the petitioner, my lord. But despite the order of this court, my lord, no affidavits have been filed by the respondents. My lord, way back in 2nd of September 2019, a report was called for by this honorable court, my lord. Your lordship kindly takes up the order dated 2nd of September 2019.
Right.
The state was supposed to file their report, my lord. Till date, my lord, no copy has been served and neither they have filed before the court, my lord. My lord, we have served everybody. But this is a case where my land has been acquired by the respondents. But I say, my lord, I am running a factory there. My lord, workers are working. Now, my lord, they say that they have acquired it and way back in 2009, I made my representation that is yet to be considered. They don't take steps. But this court, my lord, has been pleased to direct the state to file a report as to how this acquisition has taken place. But though we had prayed for delineation of my scheduled land, but no compensation has also been paid. But I am in physical possession, no problem with that. My lord, the problem is, my lord, the police officer concerned of the concerned area, my lord, comes and visits every time and threats us.
Who is appearing for the respondents? You are appearing.
But I'm only for responding.
But if your lordship should decide, we can.
Dave is appearing for the state. Where is he?
But if your lordship should decide, we can serve them a fresh notice, my lord. But if your lordship kindly fixes a date, a short date. My lord.
Because the respondents are not appearing for quite some time. So why
Yes, ma'am.
it is
Yes, ma'am.
intimate then?
Yes, ma'am, I shall.
None
But may I
appears.
humbly pray one thing, my lord? May I humbly pray? My lord, due to the ensuing election, my lord, but there is a threat perception there. But if your lordship kindly my lord, grants a status quo there, till the matter is disposed.
Not in absence of the state. Please come
All
back.
right, grateful, grateful.
None appears for the state respondents. Paragraph, let the matter appear under the,
Same heading, my lord.
yeah, it will be same heading. Under the same heading on 9th April.
Grateful, my lord.
Paragraph, the petitioner is directed to serve notice upon the state respondents intimating the adjourned date.
And may I renew my prayer on the next occasion if the state doesn't appear? Grateful, grateful.
Next.
Then, my lord, I am for the petition.
Yes. You're using an exception today.
My lord, no, my lord, my lord,
You don't need to.
whatever
use.
there is on record, my lord, my lord, wish to proceed on that. My lord, my grievance was that, my lord, the land was recorded as VT. And after that, my lord, it was acquired by the National Highway. Eventually, my lord, many of the, my lord, persons, my lord, whose land were acquired, my lord, they applied for arbitration. And my lord, arbitration was held. And accordingly, my lord,
You were heard during arbitration.
my lord,
You were heard during.
yes, yes, I do not have any, my lord, objection with the arbitration. So far as the
So
arbitration
you
is
have
concerned.
objection with regard to the implementation.
Implementation of the arbitration.
That's
Because, my lord, for VT class of land, a particular amount of compensation has already been determined by the landed arbitrator. And, my lord, that has to be, my lord, adjudicated in respect of my land and that amount has to be disbursed to me. This was, my lord, my only contention, my lord. Lordship kindly takes up page number 22 of my application.
That's the award.
That's the award, my lord. My lord, separate classes of land, my lord, Badi, Bhiti, my lord, Ayush. Those were separate, my lord, amount of compensation has been assessed. It's a general order, my lord. My lord, kindly comes to the last portion, my lord, the last line. Let this order be communicated by the competent authority NHAI and additional district magistrate LA to all concerned for information and compliance. This was my only prayer, my lord, that compliance is not being made. So far as, my lord, the amount of compensation that I am entitled to receive, I have not been made known of that, my lord. My lord, I have also made a representation with regard to that, my lord. Can it take up page 24, my lord? This is exactly, my lord, my grievance. That already amount has been determined. You are yet to pay me, you are yet to assess the amount with respect to my plot of land and pay me the same.
And copy of the award was also not served upon you?
That was my grievance, but eventually I've got that.
Yes, got it.
Eventually I've got that.
Yes. Yes. Page 7 is the last page of. Oh, this is the National Highways.
My lord, report on behalf of respondent number 3 and 4.
Yes. Page 7. Yes. Do you have any further authority to deal with all this after the arbitral award? Where is the calculation?
My lord, enhancement has been made for all classes, not only, my lord, the particular class that I am claiming to be.
Yes. Can petrol pump be a class of land? It has to either be BT or Bagan or whatever.
Kindly take some, my lord, page 4.
Cannot be a classification. Maybe there is a petrol pump on that land.
Nature of use. That's Montob.
The classification of land.
My lord, kindly take up page 14 once of my writ application. Things will be clear, my lord. Page 14, my lord, 1-4.
It's very unfortunate that the state authority doesn't know the difference between classification and right of use and nature of user. Yes. You have to comply with the order of the arbitrator. That's all, nothing else. Why? What is the class of land of the petitioner?
My lord, kindly seize, my lord, I have mentioned, my lord. My lord, page 14, 1-4, my lord.
Yes.
My lord, dag number is mentioned in the leftmost column. Jomi Sreni VT, my lord, Montobbo diesel petrol pump.
Yes. That is user.
User is diesel petrol pump, my lord. The classification is VT.
User. Very unfortunate. I mean, I don't know how the authority is working. Even in page 7, the class of land is Sreni BT. You have to consider that. Irrespective of what is being run in the land. Please come to page 7, your document.
Yes, yes.
Then, how can you go beyond this? Your report is, I do not want to use harsh words. Doesn't even appear to be by an authority. The assistant land acquisition officer gives such a report. He should be removed from his post immediately. Classification is as petrol pump. Ridiculous. Writ petition is being allowed, please pay the compensation within 2 weeks.
Yes, sir. Yes. My lord, in this case, my lord, there is, as per the government order, my lord, there is some classification of the land is there, my lord, as per the government order, land acquisition. If your lordship kindly allow me, lord, to place this document before your lordship. After that, lordship pass this order.
This is the classification, the record of rights, which is admitted by the
As
state.
per this land reform, my lord, if your lordship kindly allow me at least 1 day accommodation.
How
Lordship,
does the national highways have?
So, my lord, I am not, but lordship, I don't want lordship any kind of precedent, lordship, because lordship, allow me one, though lordship, it is their duty. And another point, if you lordship kindly consider, my lord, this arbitral award lordship has been passed in the year 2015, my lord.
Yes.
After 5 years, my lord, the sitting title was, my lord. After lordship, after 5 years, lordship, they came before your lordship, my lord. These 5 years, lordship, there is no explanation of these 5 years.
Not necessary. It's a continuing wrong. No, this is not
My lord,
necessary.
my lord, there is no pleading in his writ petition regarding this, not a one paragraph.
What has the authority done for 5 years? How do you explain the authority's delay?
My lord, the delay regarding
It should have been done immediately thereafter.
Subject to lordship time consideration, lordship, I have done our duty has already been over, lordship, once. We have disbursed
No,
it.
it is not your concern at
My
all.
lord,
That is exactly
but
what I'm trying to
If
say.
your lordship can be helped, lordship, it is their duty, lordship. At least, lordship, so that I can place this document after that this document, lordship, this government memo, lordship, regarding this classification, lordship, at 5 classes of land for the rural areas and 7 classes of land for the lordship, the urban areas, lordship.
Can petrol pump be a class of land?
For this purpose,
Yes.
lordship. For lordship, for this commercial purpose is there, lordship, for this.
That is
petrol pump.
purpose, not
Yes.
classification.
1 day, at least 1 day.
Not today.
Grateful.
Not today.
Not today.
Next.
11, my lord, I am for the petition.
Mr. Dey, I just wanted to inform, yesterday when Group 1 hearing matters were being taken up, there was no one for the state in the court. And I could not take up any matter, Mr. Dey. All the councils were busy in that another court. There was not one person representing the state. Please look into this, Mr. Dey. Please look into this. Because all the matters suffered yesterday. Please look into this.
Yeah.
Anyway, please consider. Yes. 11.
My lord, 11, my lord, I am for the petitioner.
Yes.
Here, my lord, what has happened, my lord, is land was, my lord, my land, my lord, that is being utilized by the NH. I make a complaint. My lord, not complaint, my lord, I make a representation that my land is being used. I am entitled to the compensation. Eventually, my lord, I was, my lord, made to be known, my lord, that my land was acquired long back, my lord, in by the state, and my lord, that land has been, my lord, now transferred by the state to the NH. That was already an acquired land. My lord, what I'll intend to place, my lord, is, my lord, the current record of rights first, and my lord, the report of the state. My lord, kindly seize, my lord, first page 12, my lord, of my writ application. Whereas, my lord, in acquired land, it should have been, my lord, Khotiyan number 1. My lord, in this application, my lord, the record of rights shows, my lord, that it's recorded as Rayati Sampotti. Jomi Sreni, Badi, Aush, Bhiti. And my lord, I am concerned with Dag number 774.
Sudhir Ghosh is your predecessor.
My predecessor. I am, my lord, Nitya Gopal Ghosh, Sudhir Ghosh is my predecessor. My lord, 774 Dag number that I am concerned with, my lord, Jomi Sreni is Aush. And my lord, the kindly is the Khotiyan number, it's not 1. Now, my lord, kindly takes up the report of the state.
Yes.
My lord, may I take your lordship to the page number 3 of the report, although it's not, my lord, paginated in my copy.
Yes.
My lord, kindly cease, my lord. Only, my lord, it's given, my lord, that gazette notification was once there. In under Act 2, my lord, it was requisitioned. After that, it was my lord, acquired. And my lord, no mentioning, my lord, of my whether, my lord, the award has been published, or my lord, my name is there in the list of the awardees, or my predecessor's name. My lord, what has, my lord, fallen from, my lord, the Special Land Acquisition Officer, my lord, kindly sees the last portion. My lord, kindly notes, my lord, this is a report by the Special Land Acquisition Officer, not by any, my lord, report of the advocate. My lord, writ petition is barred under the provisions of estoppel, waiver, and acquiescence. The writ petitioners are now not entitled to get any opportunity or benefit under the provisions of West Bengal Land Acquisition Act, because they lost their legal right due to non-submission of any objection before the appropriate forum under the provisions of West Bengal Land Acquisition Act. So this writ court has no jurisdiction to entertain this kind of writ.
This is only a 3-1 requisition. Oh, section 4 is also there.
Section 4 is
And
there.
after that, nothing.
After that, my lord, nothing. Whether, my lord, the award list of award, my lord, my cases, I did not know. The land was never, my lord, acquired. I was throughout in possession of the land until the National Highway came into picture. My lord, I have never known of these proceedings altogether. That is my case.
Yes, Mr.
My lord, this report ought to have, my lord, considered, my lord, the list of awardees.
Absolutely.
My lord, grateful.
Unless there is a declaration of award, grant of compensation, it has lapsed. That will not help, Mr. Dev. You will simply reject the application with the relevant documents of acquisition. Yes. Annexing all relevant, because you can understand. Representation will not help in there. He has to come back again. Yes, Ms. Raj.
In this case, Lordship, the land has been transferred, Lordship, to the Lordship in the.
How? That is the question. How is it transferred
Lordship,
without acquisition?
Lordship, as per the notification, Lordship, only these instructions I have, Lordship, from this
Because I
notification.
find only a section 4 declaration.
Yes, Lordship.
After that, no award, no compensation, nothing.
Lordship, as per the Lordship, the transfer from one government to another government, Lordship, there without any.
No, but for the initial government should own the land. Let the state come back with documents. Otherwise, there is no acquisition at all.
Grateful.
Alternate counsels for the parties. The petitioners have alleged that their land was not acquired at all. Despite which, the National Highways Authority of India, they are trying to encroach upon your land.
Yes, yes, that is my case. That is my
India is trying to encroach upon the same. Stop. The name of the predecessor and interest of the petitioners is still recorded in the. This is the RS record of rights.
RS record of rights.
RS record of rights. Paragraph. It transfers from the report in the form of affidavit submitted on behalf of the state respondents that requisition under section 3 within bracket 1 of the West Bengal Land within bracket requisition and acquisition bracket closed Act, 1948 was issued in respect of the plot in question on August 13, 1958 or 68. It says 1958 or 68.
58, no, sir.
58. And declaration under stop. But there is no document on record to show that award was declared or compensation paid to the petitioners / their predecessor within the statutory period of time. Paragraph, learned counsel for the state respondents seeks to submit a further report annexing relevant documents. Paragraph, let the matter appear under the same heading on 11th April Next,
My lord, next matter, my lord, I'll be praying for an adjournment, my lord.
adjournment. On prayer of the petitioners, the matter is adjourned. Paragraph, let the matter appear under the same heading on 15th April.
My lord.
Next.
In this matter, my lord, I appear for the petitioner, my lord.
Yes.
The earlier officer, your lordship is rejected, my lord. Lord, I appear to produce a report, my lord. The last paragraph, it's reverse to report.
Can be disposed of on that.
How?
My lord, mechanics. Discussion I have received the concluding paragraph.
Have you served the added respondent?
My lord, I don't have any particulars, my lord, so far the proposed added party is concerned, my lord. There is a difficulty.
So it's a vague application on anticipation. This petition has been made.
Liberty was granted to add the second lessee.
My lord.
Yes, that was not done.
That has not been added.
But I don't have any particulars, so far the proposed added party is concerned, my lord. My lord,
You have
answer
to
was,
find out, you have to get the particulars
my
because
lord, that day, my lord, your lordship,
My lord knows that on anticipation, the jurisdiction cannot be. So
this has not been done.
application is vague. So can they have my-
Please
My lord.
have you given a copy of
Yes,
this
copy did.
instruction?
Yes, my lord, whether I should file a report, formal report or on the basis of this, if that be so, my lord, then I'm not the, because it's internal.
That direction is already there, my lord. Kindly have a look at the last paragraph. To submit a report in the form of affidavit. Okay.
There is no redevelopment, the KMD, please come back on affidavit.
Lordship.
A report in the form of affidavit because this has to be taken on record.
My learned friends.
This has to be taken on record.
Yes.
No problem.
Learned counsel for the KMDA seeks extension of time to submit the report in the form of affidavit as sought. Paragraph, let the matter appear under the same heading on 2nd April. Because we can dispose it of. One more week.
One more.
Disposed of.
Yes, just for my convenience.
8th
So that-
April. 8th April. You can take this back.
Yes.
Mutation.
May please,
Mutual solvent property matter. The clause says that you have to construct within 3 years or within our case, my lord, after the allotment was done within this 3 years period, the allotee dies. We applied for mutation. Mutation has not been done, but at the same time, my lord, notice has been given to the dead person for resumption of land. This is summons substance.
Did you inform the debt?
I have only, my lord, placed the dates before my lord, nothing else. Kindly come to the, just for receipt recapitulation, kindly come to the deed. Page 24 is the deed. 10589. 10589. Kindly come to page 24, the deed starts.
Yes.
Kindly come to internal page 327. 6 capital A. A. There are several times deals with this. construct the building in conformity with such building rules as may from time to time be framed by the government or other authority prescribed in that manner. And according to plans, specification, elevation, design, and sections sanctioned by the government or that authority within 3 years from the date of possession of the demised land or such extended period as may be allowed by the government in writing. Well, it is not mandatory. Provision for extension is there. Now, my lord, it says that if I am violating, my lord, then it will resume. That clause is there. That is at page last. Yes, but kindly come to page 30, clause 4.
Was there any application for extension?
I'm coming to that. What happened, my lord, within the period, just give it 2 minutes time. Clause 4, if they want to invoke. Clause 4 and that clause, if read together, they have a right of resumption. Now, kindly, what happened thereafter? Possession certificate is at page 32, my lord, kindly come. That is dated 11 December 1970. Three years means 73 December. Lease died on 10th August 1973. Kindly take that note. Then, my lord, so cause notice issues. Kindly come to page 35. Yes, 35. In 1991, notice addressed to the dead person.
There is the intimation of death.
I have made an application. Better to go to that first. But kindly come to page 36. We have immediately replied. Next page. One of the legal heirs intimated to them.
Any communication prior to this?
Prior to this, there is no communication.
He died in 73. This was only in reply to a letter in 91.
Right. My submission is, my lord, unless the legal heirs are mutated, they cannot even apply for sanction plan. And if the sanction plan is not applied for in terms of the lease deed, I cannot construct. The legal heirs cannot construct.
They can
Now
inform the authority.
that part is over because of the subsequent event. Kindly come to page 38.
38?
8.
Yes.
Now the correspondence with legal heirs. So I can presume that so-called default up to 73 has been given a go by. These are the documents they have asked for from me. Page 38. Better, my lord, should read 37 first and then 38. My prayer was already there. On that basis, they have acted upon. And 38, page 38 is my response. Kindly come to 39.
Yes.
Death register certificate in original and a Xerox copy of the life certificate in original may kindly be returned to us. In view of the above, you are requested to do the needful in enable us to construct the residential house early as possible. So that this part is also there. Now, my lord, kindly come to page 56. I am not troubling with their correspondence on this line, but mutation has not been effected. Kindly come to 56.
Yes.
Can you see the date? 4th September 2001. Mutation in respect of plot number such and such at Bidhanno.
Certain documents were called for.
My lord?
Certain documents were called
Yes,
for.
that has been replied to, given everything. Now, in spite of all this, page 63 kindly come. Total non-application of mine.
63?
3.
Yes.
My lord has seen in 2001 it is continuing. They are asking for documents. In spite of that, again a notice to the dead man in 2011 for resumption. Addressed to the lessee. They are know of the fact. Records will reveal. Then we have again reply. Page 64 we replied, giving all the details what has been happened up to date. Now, ultimately, my lord, I'm not traveling with the entirety. Same thing is going on. Ultimately, they have lost everything. Page 75, my lord, kindly come. Keeping over which, according to me, is not necessary. They compelled us to file a fresh application. Then we have made this application. So this is they cannot say this is the first application. Records revealed that we have intimated to them, though late. They correspondence with us, asked for deposited document when mutation has not been effected. Now 75, I again file fresh application.
Yes.
So up till date, no mutation effect. Now the impugned order, page 127, resumption order.
127 or
127. Kindly come to 127. Well, I request your lordship to read it. Your lordship will not find anything about our attempt to get my name muted. Your lordship will not find. Death has been recorded within 3 years. Then lessee was requested to by memo dated such and such to explain 90 days from the date of issue of the letter as to why the aforesaid plot of land will not be resumed by the government. So this order letter is also on the dead man, but we have replied. The heirs replied.
This is on the heirs.
This is from the heirs. No, this addressed to heirs.
Page 127.
127 addressed to heirs, but the recital, my lord, will find.
It is all on the original.
All
list.
original, but they have never, my lord, spent a single line to indicate that the heirs also take steps. To hand over peaceful possession.
Yes.
But kindly see their own document. As I was skipping to make this short, kindly come to page 70.
70.
70. This is a reply to Right to Information Act in 2015. In reference to a letter number such and such, regarding the aforesaid matter, I am directed to send here with the reply. The respective plots was allotted to Sri Ranjit Kumar Biswas. After the date of Sri Ranjit Kumar Biswas, his legal heirs has submitted application for mutation. Not acted upon. In this
But
context,
this is not in dispute also.
there is not
They
a
have
dispute.
replied, they have asked for documents.
Not a dispute. And my lord, this subject only one judgment I always refer, my lord. Again, my lord, I am referring you, Lord, sir. 2004, volume 2, Supreme Court cases 130. Sure. Okay, just give me a minute. 6. 57. So kindly take these judgment, my lord. 2004, 2 Supreme Court cases 130. I request your lordship to read first paragraph 43. I have a bad habit of marking, my lord, kindly excuse me. paragraph 43, then 46. Wrong page.
Forty-six.
46, 49 and 57.
Yes, it's the principle of proportionality. Yes.
Well, let I read, then I'll make 2 minutes submission on that. Okay. 57, last.
Yes.
But it was found there, my lord, a statutory enactment was there. Even interpreting a statutory enactment, Supreme Court says, applying the doctrine of probability, that yes, power is there, no doubt. But when you exercise that power, addendum, or in a given case where it has been let down, payment has not been made, mischievous things, malafide attempt, then only you can do it. Here, my lord, it is an agreement between the parties. That stipulates extension, not on the first. So you have not extended it. You know mutation, unless mutation is granted, I cannot construct. So in my humble submission, this judgment squarely applies in our case where there is no malafide even alleged in the affidavit. So in my humble submission, my lord, this order of resumption should be, my lord, quashed, and a chance after mutation, a chance will be given to first time. Mutation application are still pending. That's what it was. Oh, in fact, the next repetition is subsequently physically repossessed. That is challenge. Consequence. If his my lord is with me in this,
The same writ petitioner.
second one.
Subsequent.
So if my lord is with me in this matter, then automatically that will be.
Yes.
We have submitted one report, my lord. Report of my lord, Rajiv Mondo, Rajiv Mondo.
Yes.
Is that page 3 of my report, my lord? We have stated that.
There is a supplementary affidavit on your.
On our part, showing that the building rules is applicable. So Kolkata Municipal Corporation is building rules provides for that. Unless mutation is given, you cannot do it.
This page.
Page 3 of my report.
3.
Yes, ma'am. The next one report, pursuant to your lordship direction, my lord, one hearing was conducted, but on 25th of January 2023. In the report case, the authority, my lord, discussed, my lord, in the year 1969, my lord, the plot was allotted on. Thereafter, my lord,
Possession 1970.
Position was your 1970. Thereafter, my lord, died, my lord, the original allotee died, but in the year 91.
93.
73.
70, sorry.
73 August.
73 my lord died, my lord. And when they have informed, my lord, they inform, my lord, 19, my lord, on 2nd of December 1991, my lord. 91, my lord. 4th paragraph of my report, my lord. On 2nd of December 1991, Sotri Biswas had informed that Ranjit Kumar Biswas was died. But in between this time, they have violated the clause, my lord, 26A of the lease deed.
After that,
we
you have made several communications asking them to submit the relevant documents for mutation. So it is acquiescence.
the allotment of lease has been cancelled due to my lord not utilization land more than 50 years. This is only the ground, my lord. And well, since my lord, the allotment has been cancelled and my lord, we have re-entered the possession, my lord. My lord,
And the final letter was also issued in
And one more point, madam, we have also taken, my lord, can we see page 4 of my report, paragraph 9, my lord.
yes.
Simply a mutation application received on 24th of December 2022 from Sri Satyajit Mishra. Such and such, my lord, all are distance related.
Have you rejected the mutation application on this
It has
ground?
not been mentioned in the my lord, order of resumption. This is true, madam.
And the mutation application is still pending. During pendency of the mutation application, you have resumed the land.
This point has not been taken in the, my lord, in the order of resumption.
Can you pass a direction for cancellation and resumption prior to disposing of the mutation application? You may have reasons for rejection of the same, but you have not done that.
Then you also may direct, my lord, the authority to revisit the issue after considering all these things, my lord, whether they are entitled to, my lord, mutation or not, because there is a, my lord, government order, distance relative cannot mutate their names.
Please show me the government order.
Yes, there is a government order, my lord. There is a government order. But I can show, my lord, there is a government order.
There is the order.
Another matter, my lord, I have shown to your lordship, my lord. In this matter, I have, right now, I don't have, my lord, this name of it. But there is a government order, my lord, distant relative has no, my lord, authority to mutate that.
Please show me the order.
But can we pick the date, well, I said, for the next address.
Can it be divorce?
Let's
Succession
watch
Act?
one thing. Are they distant relatives?
Why is, sorry, brother's son?
Why he is a bachelor? He has no
Yes, under the Hindu Succession Act, I am coming.
class 2 heirs.
Last 2 years, last one is not available.
I said, so you also.
Let it come back. I'll just keep it for orders because I've heard the
I
matter.
understood, but what he's saying, the government order will prevail upon Hindu Succession Act. That is the law, my lord.
There is a
Let
government.
us see what government order is there at all.
Yes, yes, there is an order.
Yes, your lordship.
There is an-
That has to be seen.
In another matter, I have relied upon for your lordship. In another matter.
In such a case for
In
mutation.
such a case, yes. All these, my lord, issue.
I'll keep it for orders. Hearing no further
Let it
hearing is
consider.
necessary. No further hearing is necessary. Please come back with the document.
Only the government.
Her learned counsels for the parties. Paragraph. Learned counsel for the respondents submits that there is a government order to the effect that distant relatives of the original lessee are not entitled to mutate the leasehold property in their favor. Learned counsel seeks to produce the said document on the adjourned date. Paragraph, let the matter appear under the heading for orders on 5th April.
Can extend the interim order. Extend the interim order, not to create a third party interest.
Till
31st it was there. 9th February order, my lord.
A paragraph, the interim order granted earlier is extended till 30th April or until further orders, comma, whichever is.
My lord, matter fixed at 11:30.
Yes.
Keep punctual, right? No? John, the
11:30 fixed matter, item 46.
Yes, yes, certainly. It's my fault, my lord, I couldn't make it.
Go to action as
My lord, I have appealed to respond number 8 to 30 led by Mr.
46.
Yes, please continue. Please take the mic.
If the suit is filed in any court having no territorial jurisdiction, what is it? That has been. And one judgment has been, my lord, it was a escape from my notice. There's in 1963 Supreme Court. Year 1963 Supreme Court, page 884. Page 5. Not all of them matters. 1230.
I do not really know whether this will continue till 12:30. Yes, Mr. Mitra, will it continue till 12:30?
Yes, 12:30 up to 12:30 today.
It will continue.
Because there is another schedule which will commence from tomorrow. 14th and 15th, there are two schedules for this matter.
Will you continue till 12:30?
Yes, 12:30. 12:30 up to 12:30.
12 up to 12:30.
Will you take time till 12:30?
Yes.
Or you will conclude before
I
that?
think I shall try to conclude my.
No, it's the other way around. Will you conclude before 12:30?
I not. It will take. It will take, my lord.
It's the other way. Matters till 12:30 are released, not mentioned matters. Yes, continue.
Your lordship, will you say that that day, what would be the effect if a party participates in a proceeding and file lead evidence refuting the allegations made by the parties? In that matter, whether he can come before the court, there is a mistrial in the proceeding and proceeding is vitiated. That is not permissible under law. That is the year 1963. Paragraph, your lordship find the page 5. Page 5 of the middle paragraph.
Page 5.
Page 5. Case is also Nedurani. Yeah. Neduruni Kamesh Sharma versus Sampati Subbarao. In middle portion of the paragraph.
No doubt.
Page 5. In bottom is page 5.
The last.
No doubt.
No, middle paragraph. Middle.
Middle.
No doubt.
Paragraph at page 5.
No doubt. Middle portion. Middle paragraph. Middle
It
portion.
starts with no doubt.
No doubt. Yes.
No doubt. No doubt. No issue was framed. And the one which was framed could have more elaborate. But since the parties, that is vital, my lord, since the parties went to trial fully knowing the rival case and laid all evidences, not only in support of their contentions, but in refutation of those other side, it cannot be said that absence of issue was fatal to the case and there will be mistrial. That is the way. So here, my lord, cases come before your lordship on 12. They did not participate. 2 days respiratory remain absent without any explanation. Then on 23/3 they came before your lordship. On that day also did not. Rather they surrendered to the jurisdiction without any objection. When there no objection is raised and they sought for filing report against the in that case, my lord, your lordship did not pass. They surrendered before your lordship because they submitted that we are ready to file report without any. So they also alleged, my lord, it is the assertion of both the parties that there should be speedy and substantial justice to the parties. Writ petition is very concerned with the speedy and substantial justice to the parties. Yes, only purpose, it is not a civil suit. We agree, my lord, it is not a civil, it is a writ petition. And the ultimate aim of the writ petition is to give the relief and substantial justice to the parties immediately. There should not be delay. But delay defeats equity, delay defeats justice. So, my lord, this is the case, my lord, they are stopped now to take the plea that that preliminary issue was not framed and that was not considered by your lordship. Your lordship considered it.
and proceeded. Yeah. Yeah. And they are selected, they did not contest the 2 days, they did not select it. Right. Now the cause of action, my lord. How the cause of action court will determine? That is a question. They raised no cause of action arose within the territorial jurisdictions of this Honorable High Court. So suit should be returned, pain should be returned or should be dismissed. That is their case. Now, our contention that because we filed a case before your lordship, stating the facts, aberrations therein, allegations therein, and relief sought for. 3 things are there. We are not going to, it is not a civil suit, my lord. We are concerned with the aberrations, allegations, and relief sought for. All are correlated, my lord. And journey should not be stopped. If journey is failed, my lord, breakdown is like, then my writ petition will fail. Whether aberrations made in the petition, whether undisputed or disputed fact. If it is a disputed fact, my lord, your lordship will ignore, will throw out the petition. If it remains undisputed, then your lordship can look into what is that. Then your lordship come into the allegations. What are the allegations made in the petition? And what relief sought for? 3 things are, my lord, are dependence on each other for determining the cause of action. So in order to determine the cause of action, first thing your lordship is to consider whether I have a right to come before your lordship, whether I have acquired any right to sue against the state of Assam. Because in partition suit, why I come before your lordship? State of Assam in partition suit is not a party. They are a third party. Being a third party to the proceeding, my lord, they intervene my right. That is why, my lord, I have. That is the cause of action, my lord. Whether this cause of action, my lord, arose within the case, this is very important facts. Because state of Assam is, if the state of Assam was a party in that case, then I cannot come. Because state of Assam is the protector of the law. Under Article 12, they have certain, they are protector of law. They cannot violate the law. Law of the land should be protected by them. Being a third party, state of Assam had infringed my right. What are the right infringed, my lord? I shall explain for your lordship consideration. So your lordship is this case, I already said that this case, writ petition has had history of its own. That case was instituted in 1960. This is the facts, my lord, I am coming. There is no dispute in that. The partition suit was instituted in 1960. And I am the one of the cautioners in that partition suit. I am the respondent. They are also cautioners. My lord, in that partition suit. What partition suit? It is no property in the partition suit. It is a self-acquired property by the parties. It is not a self-acquired property. It is an ancestral property of Hindu family. Belong to late Raja Prabhat Chandra Bora. Nobody can claim that is my own property. That is the ancestral property. That property is pending for partition before the Honorable High Court of Calcutta. Though the respondents are residing at outside Calcutta, at Assam, suit property Madhya Pradesh is also outside of Calcutta. In spite of that two facts, High Court, there is no dispute that High Court has not assumed jurisdictions over the property and parties. So by virtue of the, my valor on the strength of the Indian Partitions Act, provisions of the Partitions Act, the High Court had already assumed jurisdiction. But property has not been, because until final degree is passed, I told, until final degree is passed, nobody claimed the property is partition. The final degree order 20, your lordship, can you see the order? Order 20. Order 20. Can you see the my lord order? Order 20, Rule 18.
Civil procedure. Yes, order
Order 20.
20.
Rule 18. Degree institute for partition of property or separate possession of the share therein. So subsection 2 of section 2, my lord, define the degree. And I have already submitted before your lordship. I beg to my lord say that may not be treated as a minor repetition, because decree is a final decree. We are concerned with the final decree. There is no dispute. Here there will be dispute. My lord, they cannot dispute the final degree. They cannot say final degree has been passed. If the final degree is not passed, your lordship see the order 20 rule 18, what is the effect of that property? Decree in a suit for partition of property or separate possession of share therein. When the court passes a decree for the partition of the property for the separate possessions and share therein, then clause 2 minus subclause 2. If in so far as the degree relates to any movable property or to movable property, court may, if the partition or separation cannot be conveniently made without any further inquiry. Cannot be conveniently. They say that we have got the, my lord, they stated, they show some documents that they are partitioning. They cannot, court, because that is pending for inquiry. Without, court could not pass the decree on the basis of the preliminary decree.
This is on merits of
Yes,
the.
my lord. So that is the, my lord, that is the facts of the case, my lord, result. What is the result? If there is an infringement of the law, your lordship should interfere. I cannot ask your lordship to go to the facts. But I have a privilege to play before your lordship regarding whether there are any infractions of the rules, regulation, or law framed by the government. There are procedural violations or not. If there is a procedural violation, your lordship can interfere. There is a basic fundamental procedure of law must be followed. So here the partition suit is what it should follow. The partition should attain finality as soon as the final degree is passed. There is no dispute in this case. So in this case, my lord, admittedly, no final degree is passed. Property remains a joint property. Everybody has got equal share in the property. They have got the share, equal share. I am also got equal share. Even if fruits of means property comes out of that property, I am also entitled to get it. The government purpose of the government to acquire the land by payment of the value of the suit therein. That is the purpose. So if the property is not partitioned, I have the joint right to the property, then I am also entitled to get fruits of the property, my lord. I cannot be denied. The right to property is, my lord, guaranteed by Article 300A of the Constitution of India. So I have come for protection of my right before your lordship. I did not come asking, I am concerned about it, my lord. I cannot appreciate, pay before your lordship to enter into the disputed, decide the disputed like a civil suit. Here I am confined to the law of the land. If law of the land is violated, your lordship will interfere without any hesitations. So, my lord, that is where then your lordship can. Article 220 subclause 2, they stated that there is no cause of action. Similarly, your lordship kindly see the section 20 read with the section 17 of Civil Procedural Code. That same thing has been imported in the Constitution, my lord.
Section?
Section 17 of the CPC.
17.
Yes, 17 read with 20.
Read with 20.
Section 17 read with 20. CPC. Anyway,
Section 17. Suit for
Yes.
Suit for immovable property situated within jurisdiction of different courts. My lord, where a suit is to obtain a relief respecting compensation wrong or to immovable property situated within the jurisdiction of the different court may be instituted any court within local limits of the jurisdiction or any portions of the property is situated. That is why partition suit was filed here.
Some portion of the
Which
property.
some portion of the property there, respondents are there. That is why, my lord, this High Court in original side in book jurisdiction.
Some portion of the property is here.
Yes, yes, my lord. Some properties are here also.
My lord, it is
It
across
is not. It
pan
is
India.
Matiaga is a one of the parcels, small land out of the big land, my lord. That Raja has several properties in several places in Allahabad, Pakistan, Bangladesh, India, in different places. Ancestral properties are there. And my lord, that is the partition, and the all convent we fulfilled that partition because the property of Pakistan could not be partitioned. My lord, property of Bangladesh could not be partitioned. But there is a order, if any compensation is gained from the property of Pakistan, that will be equally distributed among them, shareholders. So that is the, my lord, that all properties, because Indian, under the strength of the Indian Partition Act, the court, these honorable High Court assume jurisdictions. Now I have come with the, when the pendants of the case, why did I come before it? Why? Which circumstances compelled me to come before your lordship?
Section 20 to Section 20 to Section 20 to 20 seat. Course of action or only part. That is Section 26.
Then Section 20, your lordships, you will see. The other suits to be instituted where the dependent resides or cause of action arises. Cause of action arises. The C, your lordship will see that cause of action wholly or in part arises. So we find in the CPC, my lord, CPC also empowers the court to entertain any suit if any cause of action arose partly or separately within the jurisdiction of that court. So similar provision has been imported in the Constitution under 226 of the Constitution of India.
226. The power.
Constitution. Yes.
Power of the High Court to issue certain writs, 226, then subclause 2 of the power conferred on the section issue directions and order writs to any government authority. Persons may also be exercised by the High Court exercising jurisdiction in relation to the territories within which the cause of action arose. In relation to the territories within the cause wholly or in part arises from the exercise of such power. Notwithstanding exercise of such power, my lord, notwithstanding that seat of the such government or authority or residence of such person is not within those territories. So it is irrelevant, my lord, whether dependent suit property is within the jurisdictions of the Calcutta High Court or residents of the parties are outside of the Calcutta High Court. It is immaterial. Whether your lordship will consider whether cause of action partly or severely arose within the jurisdictions of this court. If any part of cause of action arose, your lordship can entertain the writ petition because Article 2012 Supreme Court in Charles case, the 12 Supreme Court says a cause of action is a bundle of facts. And that bundle of facts will determine the cause of action. That is the, if any part of cause of action arose with any part of the indicated crime, your lordship will exercise the jurisdiction. So now the question is now, why I have come before whether my right to file the writ petition accrues or not, when the suit is pending. That is a primary consideration, my lord, whether my right has been infringed and whether I have right to come challenge the actions of the government, state of Assam, who is a third party to the writ petition, my original. Property is pendant, it is pendants. It is pendant like Madhyabag property. There is no dispute. It is a subject matter of the suit property, of the partition suit. But only in that suit, my lord, state of Assam or any officer are not made a party. Now what will happen? Because being a third party, they intervene my right. They infringe my right. Right which is pending for consideration before this honorable court in the Calcutta in the arbitration in the partition suit. That right has been infringed. They have also certain right under partition suit. I have also certain right the partition or respondents of partition. Whether and the property was not separated, demarcated by meets and bounds. So in that circumstances, my lord, whether my right has been infringed by the notification not. Now, your lordship time, whether that notification has given rise to come before your lordship, challenging that, it is ultra vires. It affects my fundamental right. Rights guaranteed by the 300A or not. If this notification, my lord, infringe my right, guaranteed under, then your lordship will assume jurisdiction. Your lordship will see that whether right to sue accrued, when the right to sue, because I have already submitted before lordship, suit is pending. Why I have come before the lordship during the pendency of the suit? The notification dated, your lordship see, the facts, the cause of action, I must say before your lordship, that in order to determine the cause of action, 3 factors must be taken into consideration. Averments of facts, allegations made in the writ petition, and relief sought for. Averments of facts, allegations made therein, and relief sought for. 3 things are correlated. That cannot be separated. If it is separated, my lord, I have no cause of action. If cannot be separated, it leads to each other. Conclusively, your lordship come to the relief sought for is based upon the facts, averts in the petition, allegations made therein. Then your lordship will assume judicial relief. The cause of action arose in there. Because what they pay, because it is the knowledge of the state of Assam, respondents. Because when the record shows that they have got full knowledge, the partition suit is pending.
You are again on merits of the petition, sir.
The full knowledge.
On the jurisdictional issue only.
That will be my knowledge. That facts will give the jurisdiction right. Averments made in the facts. What are my averments? Why I have come with a suit is pending. State of Assam is not a party. Being a party to the suit, they intervene by right by violations of the provision of section 52, 54 and 55 of the Transfer Property Act. When the suit is pending, this section automatically applied to the suit property of partitions of subject matter of the person who is the respondent. And that is why they place so many judgments before lordship. No judgment was passed on the subject. The subject of the suit matter is pendent right in any court. It is not, there is no, our case is that the subject matter of acquisition, your lordship see the notification. Page 80.
The writ petition.
Of the writ petition. Yeah. 81.
Yes.
81, page 81.
81.
That notification, my lord, a challenge. That notification challenge, that is annexure P4 series at page 81. That notification authorized the respondent number 4 to acquire the property, that disputed property. which is pending the doctrine of dependence is applicable, where the doctrine of correspondence is applicable. Matiabag, located Matiabag, Gauripur, ward number 8 under Dhupri. And he was the deputy, respondent number 4 was the chairman of that committee. And he was authorized to take action for the purpose of acquisition of the land for the benefit for the it is, my lord, one thing you will kindly note that notification does not say it was issued in the public interest. You will also kindly see how malafide action is there. If the notification does not contain that it was not in the public interest, whether it can be treated as for the benefit of the state interest. That is my question, my lord. That notification itself is malafide, because had there been proper bona fide exercise of power, there ought to have been assertion in the notification itself. We are going to acquire the land in the public interest. What is that averments in the notification? 2013, my lord. There is no, and in the meantime, government has already framed how because after 13, no acquisition, land acquisition policy is available, my lord. All has been redundant. Because after 13, new act has come into operation. Central Act has come into operation. So they are to go by, because they have cannot exercise their old act. They cannot exercise the power under old act. They are to exercise the power under the new act, the Central Act of 2013. So that notification is, whether that notification is my right or not, as I accrued that whether given any right to file the writ petition. What is the transparency in this writ petition? Acquisition. Acquisition must, or notification must carry bear that it was done in the public interest. Where there is no whisper in the notification that it was done in the public interest. What is there done? It is done in violations of the provision of section 52, 54 and 55 of the Transfer of Property Act and Indian Partition Act. Not only that, that notification also appears to be contemptuous one. Because administration of justice, partition case is pending before the Honorable High Court, Calcutta. It is a subject matter administration of justice to the parties. They are aware of the facts that is pending for the administration of justice in the High Court. They, by notification, they interfere with the. That is amounts to contempt also, my lord. Though the contempt is between the court concerned, my lord, I have no right to say regarding it, but it is purely concerned with the court and the parties, my lord. But it cannot be overlooked by your lordship. When it is come to the notice of the Honorable Court, any order passed by any authority contravenes the amounts to contempt of court. That is the latest decision of the Supreme Court. I will show you, lordship. Their lawyers, their Supreme Court says that. Yes, violations of section 52 does not invalidate the any transaction. It will come effect after SUVRA before 2023. Now the Supreme Court says, no, when it will come to the notice of the Honorable Court, any transactions of the land by any authority is done in violations of the courts in interference with the administration of justice, then that document shall be declared illegal. That is, my lord. So that is my lord, that had infringed my right pending in before the Honorable High Court at Calcutta. That notification directly affected my right of adjudication pending in the High Court of Calcutta. So that is why that has been challenged in this case, my lord. Second thing, my lord, I also challenge the annexure, page 80 That is, they stated that relief I sought for that and Annexure 80 only. I did not seek. But both the notifications are under challenge. From the amendments of the writ petition, your lordship find. I will read the writ petition. I challenge both the notification. It's page 80, your lordship kindly see. Page 80, what it? That is the payment. Payment of the award. Whether it is a bona fide or whether it is, my lord, mala fide under in view of the provision of section 52, 54 and 55. If this notification goes to say that it was done with bad faith by the state of Assam, in order to give certain privilege to unfair privilege to the certain parties, your lordship will interfere. It is ultra-vires. And that has increased. They had given the benefit infringement by right. That benefit is being given to the parties by infringement of right to the property pendant right in the Guwahati High Court. So your lordship, see that right has infringed, because that right, whether I will get the property or not, or my share or not, that is sub judice. That is, doctrinal jurisprudence has come into operation. And section 55 of the Property Act casts responsibility upon the state of Assam to inquire whether these matter, whether this property is free from any encumbrances or not. It is the first duty to see that we have checked bona fide. That notification, my lord, has been issued after having full knowledge of the documents that remains under consideration before the High Court. And whether district judge can usurp the functions of the High Court. It is also consideration, my lord. Whether district judge, your district magistrate, respondent by who, you can usurp the functions of the administrative justice of the High Court. Documents which are lying in the High Court. High Court is the court of records. So documents are lying under the custody of the court of records of the Calcutta High Court. And if these documents, whether they are right to appreciate, whether it is right or wrong, any appreciation is permissible. Whether he is authority to interpret any documents pending before the High Court administration of justice, pending for administration of justice. That your lordship will see that they strongly relied on that page 2 to the annexure R15, page 2 to 21 government, page 2 of the report. They submitted, my lord.
Submitted by the state. Page 201. Relevant pages, page 202.
That is first page, and firstly it is found. Your lordship got it. Page 2001, 201, annexure R15.
Speaking order.
Yes. R15.
Why that parts will come under the allegation, my lord. Whether my allegations made before the honorable court, they infringe my right by illegal exercise of power, unauthorized exercise of power vested upon them, my lord, whether it is a colorable exercise of power or not, then your lordship can look into. Your lordship see that document. Then that document, my lord, 8/12/22, which is the first paragraph shows that. That not annexure under challenge, my lord, annexure under challenge P4 dated 4/7/22. My lord, before that another notification issued. Before that another notification issued constituting a committee for acquire that land. Here we kindly see page 8/12/22. Whereas the government of Assam in the central government had formed a notification and purchasing committee for purchase and transfer of Nagara Place and transfer of Matia Place, Gauripur, under government notification dated 12/1/22. Where is that notification? They did not produce that notification in the with the, as per approval of the state cabinet. That notification is 12/1/2022. Our notification challenge before your lordship, that is a 4722, Annexure P4 series. Where is that notification? That notification was not given. Because if the committee is there already, whether another committee without dissolving them, another committee can be framed for the same purpose.
I'm afraid these are all on merits of the writ.
I didn't stop my understanding.
You are submitting on merits of the writ petition, sir. We are dealing with the short issue of jurisdiction only, nothing else.
Jurisdiction, your lordship, that is there because the allegation, making submission, my allegations made in the petition and relief sought for, that whether that has given right to come before your lordship to him. My first question, because they can now, there is no stage for raise the jurisdiction, lack of jurisdiction. Lack of jurisdiction does not invalidate the proceeding. That is first question already argued. Now the second question, there no cause of action arose. I am confined to that.
No cause of action arose within the territory.
Within the territory.
The
Without
jurisdiction.
no cause of action within the
Not that
territory.
no cause of action
Within
arose
the
at all.
territory. Whether it will come to the jurisdiction, because if the right is infringed, pending in the administration of justice of the High Court, whether they can be said that it is out of jurisdiction, it is not relation, it is not directly, it is not so therefore this by so that is why they by this illegal decisions or notification, whatever might be, as I brought it to your notice, has increased my right. And that has given me right to file the writ petition. That question was first considered by the Honorable Supreme Court in 1960, Rambai case. When right to sue accrues, when right to writ proceeding accrues. 1960, Rambai's case, my lord. 3 judges bench. Similarly, my lord, the partition was involved. Their question comes, one document was executed by the parties. Other party has come with this partition to because that cannot be challenged barred by limitation. In that case, Supreme Court says no. When that notification infringes the right of the parties, when the notification threatens the right of the parties, then right to sue accrues on that date on the basis of notification. That your lordship will kindly see there 1960 Rambai's case. And before that, my lord, your lordship will kindly see that I made a representation before the acquisition or passing of this order. I filed one representations before the court. Before the revenue authority. Their litigation is pending. They suppress that fact in this order. They did not take it into consideration. What they taken into consideration? The subsequent notification dated 17/10/2021, my lord, which itself shows that my earlier notification was enforced. Your lordship can see. Page 2, your lordship can see.
Page 2 of?
Because my lord, learned senior advocate referred this order, they relied on that.
You suppress this way.
Suppression fact, I will come, my lord. Suppression of fact, mere suppression is not.
I relied upon it because you did not
Yes.
show it.
Your lordship can see the facts. There is no disputed facts. If they can show that there are disputed facts in their case, then your lordship can say, and these facts which is omission is amounts to fatal to the case. Without it, court cannot pass any order. In that case, it will also interfere. Suppression of fact will come into operation. Suppression must be material fact, not ordinary fact. My lord, material facts without which court cannot proceed with, pass the judgment. That is the decision. So that is here the court, there is no embargo in there to your lordship to decide the facts on the produced by the state respondents. My lord, there are page 2, 202. Where is the 17?
Yes. Yes.
Paragraph, whereas the 17th October, your lordship, fair petition was received in his office from the Mousumi, petitioner number 1,
Yes.
daughter of Ray Tonokumar, who is also another son of the Ray. In that petition, Mousumi has stated that she came to know about the purchase of Hotanama from media report, and that report, Prakash Bora had gone ahead with the negotiation without settling their family property dispute. Srimati Mousumi Bora mentioned about the decree by consent passed by the Honorable High Court of Calcutta, 1960. And that is in the last para. Hence, my lord, that is an interference of the court. Hence, from the two documents, but these documents under consideration of the High Court did not arrive any decision on that point. Did not appreciate the documents till now in the partition suit. Now, what he did from the above two documents, it is established beyond doubt that for the aforesaid Dagnaman Matyaba Gauripur, 4 sons of Piktistan are rightful beneficiaries of the compensation. That is, then he acted as a partition, so he has given the benefit because there are no need of partition. He invalidated the partition suit totally. And the two complaints received do not stand at least in the context of the purchase of Okanama and payment of the compensation thereof of the amenity. That is, you kindly see the lordship. Whether he can adjudicate the district responsible for this property. That is why, my lord, my right has been threatened. When my right has been threatened, my lord, I have come before your lordship. That is, your lordship will kindly see the judgment. Ram Rukbai. আরেকটা জাজমেন্ট করি আরেকটা দাও ম্যাডাম Page 3, your lordship kindly see. Page 3, middle portion, my lord. Here there is the Supreme Court. Right to sue. Right to sue under Article 120 of the Limitation Act.
Yes.
Page 3.
I've got it, please.
Accrued when the dependents clearly and unequivocally threaten to infringe the rights asserted by the plaintiffs. So, my right to file writ petition, that is a compulsory, that is why I submit with your lordship, that is a compulsory cause of action. That has been arisen on 4/7/2022, affecting my rights, infringing my rights, pending for adjudication before the High Court of Calcutta. That is my, and that has compelled me to come.
I am not contending for my petition.
That is what I'm repeatedly saying. It's only on the jurisdictional point, not on anything else. Yes. You definitely have a right to sue. That is not challenged. Your right to sue is not challenged by the. You definitely have a right.
My lord, because they stated that I have already submitted, my lord, that abatements of facts, allegations made in the plaint, writ petition and relief. These are correlated. What are the abatements? What are the allegations? Allegations, these are the allegations. These are the allegations I am showing that my right, how my right was threatened. How I was deprived of by the right to join property by arbitrary act of the state of Assam. Whether state of Assam, my question, I have come for decision whether action of the state of Assam during the pendency of the suit, partition suit, infringe my right is sustainable or not. Whether it will come enabled under the jurisdiction of this court. This notification, which has infringed my rights, ascertained in the partition suit, whether this notification will come within amenable jurisdictions of the jurisdiction of this court. My respected submission, my lord, your lordship, as soon as the notification has been issued, that your lordship can assume jurisdiction. There is no cause of action shall be deemed to be taken within the jurisdiction of the Calcutta. Because High Court is the court of records. Your lordship cannot ignore that fact. If there is any case for that, despite of pendency of the case, the court, my lord, government and authority, that it is out of there. No judgment has been shown. I have already said, whatever judgment they shown regarding territorial jurisdiction, my lord, those are not relating to the sub judice property of the suit. No property is pendent alike in that suit. Our case is different. Our case is that why I have come before lordship, whether that notification has given right to come before your lordship. So this I am saying that is the allegation, my lord, that has come into operation as soon as infringed my right on 4/7/2022. They infringed my right, which is under consideration of the High Court. And that notification has direct nexus with the subject matter of the partition suit. So that cannot be isolated. So that is the cause of action arose within the touching the jurisdiction, the administration justice of the High Court. In part or fully, so there is no dispute with it. They cannot say no cause of action has taken place. Now, my lord, if your lordship says that I have no cause of action, then print should be returned to me to file it. Whether that is, I have already stated, that stage has already gone. The right to claim to trial the suit in any other court, that right is already extinguished by their conduct. Conduct of the parties before the honorable court must be fair. If your lordship is satisfied that the parties who has come before the honorable court by suppression of material fact, not bona fide or malafide relief, my lord, then he is not entitled to get relief. So, in order to, my lord, bring me out of this honorable court, they must satisfy that the Mr. Purkasto has brought some disputed facts in this case. If they can say that I have brought the dispute, I have no case, then they have to show the allegations made therein. Facts and allegations, both are correlated. Allegations made therein are false, not in existence. If your lordship says that the allegations made in the petition is found substantial, infringe my substantial right, guaranteed by the Constitution, your lordship will interfere under Article 26. So here, my lord, the allegations is that, what are the allegations? Your lordship says that without allegations, I cannot satisfy your lordship the cause of action. I can, if I am not permitted to allow my allegations, my lord, against the state of Assam, I cannot say that I have been paid. So my allegations, I may be permitted to say the allegations brought in the petitions. Then your lordship can say, he relied on para 22 of my cause of action, what I stated, relief sought for. Your kindly, I will come to the relief sought for. Three things I made special submissions before lordship, three things should be interrelated, cannot be isolated.
There is no dispute with regard to this.
He is disputing, my lord, because the cause of
Disputing the jurisdiction, not
jurisdiction leads. That is why my submission is the jurisdiction leads to jurisdiction, right to sue and jurisdiction. Our right to sue accrues. Without right to sue accrues when there is a cause of action. If no cause of action, I have no right to come.
Right to sue has also not been challenged.
The suit any writ proceedings, my lord. I must certify that I have a cause of action. If I have no cause of action, then I cannot.
Dispute at all.
Eh?
Your cause of action is not in dispute. Only the jurisdiction. Where should you have filed
Cause of action, whether it is touching the jurisdiction, the High Court of Kerala.
whether it
Whether-
should have been before?
Yes,
the
my
Supreme
lord.
Court?
Whether this notification, my case is that whether the alleged notification under challenge, whether was made by infringement of my right ascertained in the partition suit.
That you have submitted.
Eh.
That you
Then, my lord, whether infringe my right in the partition suit, and whether this notification is a deprivation of the right to property guaranteed under Article 303 of the Constitution. If Article 300A of the Constitution does not say that should be here within Calcutta High Court. Property must be in the Calcutta High Court. So this Article 300A means a joint property. Property which is from which I was deprived. Their property, whether under the adjudications of the Calcutta High Court not. If your lordship holds that it is within the jurisdiction of Calcutta High Court, I have right. That right accrued and cause of action accrued on 4/7 within the territorial jurisdictions of the High Court.
That's all.
That is my second, my lord. Then allegations, my lord. Allegation. What are the allegations?
Allegations will be dealt with
Allegation
when we
also, my lord. Allegation also relates to cause of jurisdiction, my lord. And relief, because they relied on that, my lordship. They read the my petition, writ petition. Your lordship, kindly see the writ petition of what I stated, my lord. Paragraph 7.
Yes.
Page 6. Whatever. Next please. Next please. Next, please.
Your lordship, see the paragraph 7.
Yes.
That is a subject matter of partition suit. Then your lordship, paragraph 8. Petitioners say their are sons of legal minor and title interest in respect of the property in partition suit.
Cannot claim.
1993.
Assaulting বললেন না, cannot claim.
Pura cannot claim right. They cannot claim right, title, interest in respect of the property partition suit 993 of 1960, which does not fall within the share of the original defendant proclamation as per preliminary decree dated passed in the partition suit and as per report dated submitted by the commissioner. That is my case, my lord. So I am the shareholder. Then your lordship come to the Choddo, my lord. Choddo. Page 10, paragraph 14.
Yes.
Petitioner states that in reply to the letter 17/10/20, petitioner Mousumi Rai, respondent number 5, the additional deputy commissioner SLPC Dhubri, Assam, letter dated 20/10/22, furnished 3 copies of the letters and documents, including the notification dated 4/7, bearing the is purported to have been issued by the respondent, but to the Secretary of Government of Assam Culture Department dated 4/7/92. It is in that Government Assam has been pleased to constitute 8 officers, including the DMN collector and Dhubri, a chairman, for the purpose of negotiation and purchase and transfer of the palace of Matiabag Dhubri, which is a subject matter of the partition suit. Which is subject matter of the without disclosing and indicating the name of the owners of the suit property. Palace Matiabag. From the letter dated 10/10, that is my from the letter dated 10/10, Director of Culture of Assam, Guwahati, in land and place were required, the government of Assam regarding development of my lord, was held on 7/10 and rupees 1,15,000 crores was going to be released. They are going to, that is why, my lord, I have come for restraint them, not to release the property, which is under dispute. They are going to be released in favor of the Deputy Commissioner Dubri in acquisition of land of Mathiabek with developing the land of LTA. By that letter, Deputy Commissioner was further requested to submit 2 number of state with the bank details on behalf of the Deputy Commissioner to him through mail. So urgent, my lord. No time was given. So hurried, my lord. Within 2 hours, transaction took place. The form without fail and further necessary action. Then para 15. The petitioner states there, publication of the said notification contained in the letter dated author. None of the 8 officers mentioned in the notification had come into the petitioner for negotiation for purchase of the said palace at the Mathiabek Dubri, which was allotted to the share of the petitioner's lady and 2 daughters, legatee owners of the Pramod Chandra Bohra, by premier degree dated author, that is. Then para 16, the petitioner submits that cabinet decision dated, then cabinet decision dated 7/10/22. That is a 7/4/7, my lord, it is wrong. As contained in a letter dated as represented, that is, as I said, that Mathiabek Palace is the subject matter of the partition. So, subject matter of partition which could not be taken away without following the due procedure of law.
Everything pleaded.
That is pleaded. Whether due procedure of law was followed or not. That is why I am relying on judgment mind. What is the due procedure of law? It will take time, my lord.
Continue on the next.
It is already scheduled for tomorrow.
Please confine your argument.
So I am
to the
concerned, my lord.
jurisdiction.
Your lordship, it is settled law. CPC is not applicable. But principles enshrined in the provisions of CPC, that can be, should be.
That's all right.
That is a settled law.
You are
That is not,
counting the merits also.
I cannot go
That's the
dispute it. That is why, my lord, if the cause of action, if my case is that if no cause of action arose, and since I filed a case, and your lordship already taken up the case for decide on merit, in that case, their right has been extinguished. Totally extinguished. They cannot come. Now your lordship is to proceed with the case, either rightly or wrongly, to give the decision, give the substantial right to the parties, considering all the issues involved in the writ petition. There is no scope to come back at this stage. My responsibility, there is no scope to come back. If no cause of action is arose within the Calcutta High Court, for argument's sake.
Tomorrow at 11.
Tomorrow at 11:30.
Mother, I'm obliged, my lord. I'm appearing. My learned friend is there. My lord. Tomorrow I'll oblige.
Omlan? Omlan নামটা নিয়ে নেবেন। I'll pass it on.
Obliged.
All learned counsels for the parties, let the matter appear under the same heading for further consideration on Kalki briefing at 11:30 a.m. Tomorrow 11:30.
Obliged. It is obliged.
Yes, mention matters.
Yes.
Next matters 682.
I'm for the
What's the date for the respondents?
private respondent made an.
Have you served the private
Dara,
respondents?
Dara.
You know,
Private respondent made an illegal and authorized construction over the PWD in this
Yes.
Private respondent made an illegal and unauthorized construction over the PWD land. Thereafter, your petitioner made a representation, page 43, before the respondent authorities, but the respondent authority did not consider. And after filing of the writ petition, my lord, the respondent number 7, the assistant engineer, Krishnanagar Highway Division 2, my lord, made an inspection on 10th January 2024. Thereafter, no reason order was passed. My lord,
When an inspection or demarcation has been done. Demarcation has been made.
inspection has been conducted. Whether the demarcation has been done or not, that portion, my lord, I cannot see.
This is a demarcation notice.
Yes, yes. It is the notice of demarcation, but till now, no reason order was passed. Kindly, my lord, time frame.
I'll give a direction for a time frame.
Yes, yes.
Time bound disposal.
Yes, yes. Great.
Affidavit of service. None appears for the private respondents despite service. Paragraph, the petitioner claims to be the recorded owner of the plot in question and submits that the private respondents have raised unauthorized construction by encroaching upon a portion of PWD land adjoining his property, comma, thereby obstructing his egress and ingress.
Good.
The petitioner submitted a representation in this regard before the concerned authority on 7th November 2023.
Yes.
Which is yet to be considered. Stop. During pendency of the writ petition, the petitioner received a notice issued by the assistant engineer, Krishnanagar Highway Subdivision number Roman 2 on 2nd January 2024, requesting the petitioner to attend the demarcation
At the time of spot
of
inspection,
the
petitioner was present.
plot in dispute on 10th dispute to be held on 10th January 2024. Did you attend the
Yes,
demarcation?
yes,
It has
yes,
been held.
Yes.
Paragraph. Learned counsel for the petitioner submits that demarcation has been made on the said date. Stop. No further communication has been received by the petitioner till date. Paragraph. Upon consideration of the, it is submitted on behalf of the state respondents that the seventh respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, this court is inclined to hold that since demarcation of the plot in question has been made by the concerned
Respondent number 7.
by the 8th respondent, the block land and land reforms officer.
Yes. Yes.
By the 8th respondent, comma, the 8th respondent be directed to submit the demarcation report before the 7th respondent within 2 weeks. Demarcation report within 2 weeks from date. Stop. Upon receipt. Yes. Report will be submitted within 2 weeks. 2 weeks from the date of communication of this order, from date na kore. Stop. In the event encroachment upon PWD land or any portion thereof is found upon demarcation, comma, the seventh respondent be directed to initiate proceeding under section 10 of the West Bengal Highways Act 1964 and take the proceeding to its logical conclusion within 2 months from the date of receipt of the demarcation report, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, comma, in accordance with law. Disposed of which of them?
Grateful.
Next.
May it please your lordship, my lord.
Lordship, prior to my learned friend comments, Lordship, the impugn order is an appealable order. Lordship, kindly keep this mind.
51.
Rule 51.
May I file my report? Last one, Lordship, directly me to file report.
Report on issue one. 51.
My lord, may I submit, my lord?
Where is the impugned order?
Lordship, the order impugned is at page
137.
137.
My lord, 136.
It starts from 134, that is the communication, and the order starts from page 136.
My lord, may I please, my lord?
It's an order of the ADM DLLRO.
Yes. The order was passed.
Applicable under Rule 51.
My lord, kindly see. Your lordship's order dated 3rd of my lord, January 2024.
Yes.
I have elaborately submitted as to why, my lord, the alternative remedy will not be a bar. I have already submitted a decision in that regard, which is reported in 2023 SCC Online 95 on the previous occasion. My lord, the issue is not yet res intriga. In view of the fact that, my lord, kindly have a look at, my lord, the said decision first, and thereafter I will come, because, my lord, on that day I have elaborately submitted this decision to your lordship, my lord. Kindly take your own copies also there.
Yes, I have this.
Paragraph 4, 5, and 6, and 8. My lord, kindly have a look at the paragraph 8. My lord, paragraph 4. Before answering the question as we feel, they asked to say that the words and the exercise of the writ petition conferred under Article 226 of the Constitution, having come across the certain orders and the passed by the High Courts and the holding the writ petition as non-maintainable, merely because of the alternative remedy provided by the relevant statute has not been pursued by the parties desirous to invocation of the writ jurisdiction. The power to issue of the prerogative writs under Article 226 is the plenary in nature, and any limitation of the exercise of the such power must be traceable in the Constitution itself. Profitable reference to this regard and may be made under Article 329 of the ordinment of the similarly worded article in the Article 226 does not, in terms, impose any limitation or the restraint on the exercise of the power to issue of the writ. While it is true that the exercise of the writ powers, despite the availability of the remedy under the very statute, which has been invoked and has given rise to the action impugned in the writ petition, ought to be made or not to be made to a routine manner, yet the mere fact that the petitioner before the High Court in a given case has not pursued the alternative remedy available to him, it cannot be mechanically be construed on the ground for his dismissal. It is axiomatic that the High Courts and the bearing in the mind of the fact of the each of a particular case have a discretion whether the entertain of the writ petition or not. One of the self-imposed restriction or on the exercise of the power under the Article 226 that have been evolved through the judicial precedent is that the High Court and the should normally not entertain a writ petition where an effective and the efficacious alternative remedy is available. At the same time, it must be remembered that the mere availability of an alternative remedy of the appeal or the revision, which the party invoking the jurisdiction of the High Court under Article 226 has not pursued, would not oust the jurisdiction of the High Court and render the writ petition non-maintainable. In a long line of the decision, this court has made it clear that the availability of an alternative remedy does not operate as an absolute bar to the maintainability of the writ petition, and that the rule which requires the party to pursue the alternative remedy provided by the statute is a rule of the policy, convenience, and the discretion rather than the rule of law. though the elementary need to be restated, that the entertainability and the maintainability of the writ petition are the distinct concept defined, but the real distinction between the two ought not to be lost sight of. The objection as to the maintainability goes to the root of the matter, and if the such objections were found to be substance, the court would be rendered incapable even receiving the lease of the adjudication. On the other hand, the question of entertainability is entirely within the realm of the discretion of the High Court. Writ remedy being the discretionary, the writ petition, despite being maintainable, may not be entertained by a High Court is a very many reasons, and the would be the refused to the petitioner, despite setting up of the sound of the legal point. If the grant of the claim relief would not further the public interest, hence the dismissal of the writ petition by the High Court, or the ground of the petitioner has not availed the alternative remedy, without, however, examining the whether the exceptional cases has been made out by the such entertainment would not be proper. Then, Miller 5. A little after the drawn of the Constitution bench in the court of the decisions.
Paragraph 8 will be relevant.
Yes. That about we may also, paragraph 8 I am referring. That about as we may usually refer, the decision of the court in reported in the such and such, what appears on the plain reading of the former decision, whether a certain item falls within the entry of the sale tax statute, raises a pure question of law. If the investigation into the fact is unnecessary, the High Court could entertain the writ petition in its discretion, even though the alternative remedy was not availed of. And unless the exercise of the discretion is shown to be unreasonable or the perverse, this court would not interfere. In the latter decision of the court on the found the races, they kindly see the last 4 lines. What follows from the said decision is that where the controversy is purely a legal one, and it does not involve the disputed question of fact, but only the question of law, then it should be decided by the High Court instead of dismissing the writ petition on the ground of the alternative remedy being available. So, Milord, the exercise and Milord, my endeavor would be to demonstrate before your lordships whether there is any question of law is there and which needs to be adjudicated by your lordship, Milord. Kindly have a look at your lordship's order.
Or whether it pertains to disputed questions of fact. That is also.
Yes, disputed questions of fact. Milord, this is a clear case of Milord.
Since this is to be considered in detail at length, so let the maintainability issue be kept open, and the matter be heard on merits as well.
Milord,
so that I can combine both, and I'll pass necessary order.
Milord, only the difficulty is this, Milord. The lease has already been expired. By dint of the provision of the conditions of the contract, it is a case of the interpretation of the force majeure clause.
Yes.
By dint of the force majeure clause, a certain period was there for which I have been prevented from executing the work. They have, Milord, on previous occasion I have submitted before your lordships. Your lordship was kind enough to give them a direction so that they can file their report. They have also filed their report, which I have received yesterday. They did not say anything. Only they have said there is an alternative remedy. Apart from this, a logic has been, Milord, cast, and Milord, that has been deduced by them, saying that since you have already excavated a certain amount of the sands, therefore you are not entitled to, there is no loss at all. So it is not the, Milord, the quantification of the loss. They are not there. Only the thing is this, whether the interpretation of the clauses of the contract would be made in my favor or not, in view of the, Milord, the clause 5, which has been engrafted in the conditions of the contract.
Do you want to use an exception to the report?
No, not required. There is no disputed question of fact. Only for the interpretation of the law.
Come back with a.
That's why, Milord, I have.
Now, when a lease is granted, there are certain mind plan and environment clearance that has to obtain vegetation. Now, in the environment clearance as well as the mind plan, there are mention of minimum and maximum directed production in a particular year. It is not a case that due to COVID, a certain period was complete lockdown, so we could not extract sand. Now, the thing is, you also kind of appreciate about this. In terms of the mind plan, in a particular year, the lessee has to obtain minimum of 100 and maximum of 200. Now, if it is found that within that particular year, the lessee has obtained 110, so he cannot say because of the COVID, I could not extract sand, so you can extend the time period. These are the question of fact that has not been petition. That I was under the terms of the mind plan or environment clearance, I was supposed to obtained 100, but due to COVID or lockdown, I could not achieve 100. I obtained only 20. So that is not the question or the case made out in the writ petition. These are the disputed question of facts. Writ court cannot intervene in this factual aspect.
Will you come back with a report?
Because on the last one, the state said.
State has filed a report today. He doesn't want to file an exception to it. So whatever you are saying, let that be put on affidavit.
Miller, subject to your lordship's kind correction. If you, Miller, put it in a different way, they cannot make out a case right now. Scope is very limited. We have challenged the propriety of the order, which has been passed by the DM, pursuant to a lordship's direction, which has been passed by this honorable
Not
court.
really challenge the propriety, because the earlier order was not on merits.
No, earlier was not the merit. There was an omission. There was a culpable omission on the part of the authorities not to consider my representation. Subsequently approached before your lordships, and we have categorically stated, and your lordship was kind enough to observe the entirety as to why the consideration is required.
Yes.
It is not that they simply sit are sending the matter for the consideration. By giving a go-by of the Milord, the observations which has been mentioned in your lordship's order, the district magistrate has gone into a far away by interpreting the clauses of the contract, what is called the force majeure. This point never been taken, and this is not the Milord, the cynosure of the judicial review in the instant case, Milord.
Calling for a report, a separate report from the development authority, only on the ground that what the point that the issue that he's raising is relevant.
Milord, may I submit, Milord? Assuming that, Milord, suppose, Milord, he is correct.
Whether you have suffered loss due to force majeure.
Milord, this.
For filing the petition.
Milord,
If you have not suffered any loss, then for what the extended?
Milord, the provision is this, Milord. This provision, what he is saying, in a, Milord, in a contract, normally the contract would be interpreted in a manner so that the party, Milord, there is a contra proferentum clause. Who has drafted it? If there is any confusion, that will go in favor of the person, Milord, with whom the Milord agreement has been made.
Absolutely.
So, on the basis of which, this, Milord, the contract does not say anything about that I have to extract X quantity of the sand. It is merely a permission subsequently granted by an environmental clearance. This is only a measurement, and, Milord, this is nothing but an, on the pro rata basis, Milord, this is nothing but an assessment that what kind of quantity you can extract. So, it neither here nor there in the agreement does not contain. If the agreement does contain such kind of a clause, I would be out of court.
But the agreement doesn't contain this clause.
So, only, Milord, I am seeking for an interpretation that if there is a specific ban issued by the DM itself, and during the COVID, I have been prevented from executing the work, they cannot, Milord, make out a case during the, Milord, the imposition of the, Milord, this ban. I executed the work. In that event, I can be dealt with. In a subsequent period, Milord, I have extracted a sand. So, it is not my case that what quantum of the sand I have extracted. My case is this: there is a specific clause. If I would be debarred from extracting during the tenure of the 5 years. Yes. In that event, in simplicity, Milord, this is an interpretation of the clauses of the contract, more particularly, Milord, the force majeure clause, which have been embedded in the contract. With humility, Milord, I am submitting, Milord, no report is required. In that event, Milord, since this is an interpretation, and I sought for a declaration that, Milord, the order which has been passed, that is contrary to the provisions of the conditions of the contract. I am not seeking anything, any favor. Only I am seeking the interpretation of the contract. If your lordship pleases, hold that the force majeure clause would be applicable, and this is the intent and the spirit of the, Milord, the clause. In that event, Milord, the purpose would be served in my favor or in their favor. So there is no question for, Milord, in the future also in the same issue, because I have brought also, Milord, the definition from the Black's dictionary, what is the meaning of the terminology and the connotations of the force majeure clause, and when that would be applicable.
Yes.
When the court will exercise jurisdiction, in the event, if the petitioner has not suffered, ultimately it's a commercial agreement. The motto of the parties was to government improve the portion.
I think your contender should should be on record in the form of an affidavit, because he is taking a different ground altogether. That has to be considered while disposing of the.
Milord, your lordship is aware about the fact that, Milord, since I have been challenged in the affidavit, Milord, they cannot change their case. There is a remarkable judgment, my lord. There is a path-breaking judgment is there.
He is taking certain grounds which need to come from the authority.
My lord,
Let him come.
my lord.
Mr. Shah, will you?
My lord, only my lord, I am begging before your lordship, my lord, for a particular date. Otherwise, my lord, the matter would be infructuous.
Yes,
In
for
a particular
yes.
date when the matter would be taken up for your lordship, my lord.
Definitely, I'll fix a date. I'll keep the issue of maintainability open so that I can decide both together.
My lord.
For learned counsels for the parties. Paragraph learned counsel for the seventh respondent seeks to use submit a report in the form of affidavit in this matter. Paragraph let the matter appear under the please serve an advance copy.
Yes, I will give.
Yes. Yes, yes. Report in the form of affidavit submitted on behalf of the state respondents is taken on record. First line of it. When will you come back? 18th April? The issue of maintainability is scheduled.
My lord, 18th April at 12:30, my lord, if your lordship pleases.
12:30 will not be possible. Come back, I'll deal with it. No, under the same heading. যেহেতু measurement নিচ্ছি না আমি এখন যা হেডিং এ যা থাকছে থাকবে measurement নিচ্ছি না
Under the same heading that would be there.
same heading.
Great.
684.
684, I am for the petitioner.
Yes.
The affidavits of service, my lord. The petitioner purchased, my lord, some portion of the Doba land. And Doba land. And private respondent also purchased some portion of Doba land. I have mutated my name. Thereafter, a few days ago, the private respondent, without changing their nature and character, without obtaining permission from the BLLO, my lord, filled up the pond. I made representation before the authority. Authority did not take any steps. This is my presentation. Till today, need to.
My lord, we have caused inquiry, my lord, in this aspect, my lord, and 4C.
This is land reforms at 4C.
That is the that was the.
That is what I felt. This court is not a jurisdiction, sir. This is under the Land Reforms Act.
Yes, my lord, I have made objection before the authority. Authority did not take any steps.
Under the Land Reforms Act, right?
Land Reforms Act, all right, my lord. I have only, my lord, prayer, my lord.
Not all right. This court
That is the only.
My lord, I have made objection before the authority.
Maybe.
Authority did not take any steps.
Yes.
Steps for they are not changing the nature and character or obtaining the order from the authority. Build up the manual. This is the remedy before this honorable court.
Not the remedy before this court, sir, because it pertains to the Land Reforms Act. Any matter connected to specified acts cannot be dealt with by this court. It has to go before the appropriate forum.
My only prayer, my lord, kindly consider the representation, nothing more. Nothing.
Not be. I have to dismiss on this ground. I can grant you liberty to approach the appropriate forum. If you withdraw.
My lord, kindly taken up another day when I just satisfy before the whether the matter will be referred to the LRTT or this court, my lord. Kindly take up another day, my lord, fix it.
Very well.
My learned friend cannot improve upon, my lord.
No, actually cannot.
But although we have a report has arrived with regard to their status, but
It's the statute. I cannot go.
yes.
Any representation under the sun cannot be directed to be considered.
Yes, my lord.
How can you improve on this? How can you develop your case?
My lord, kindly I shall satisfy before your lordship.
That's what I'm asking.
But whether this court has entertained this matter or
Please come to the West Bengal Land Reforms and Tenancy Tribunal Act. Do you have it? Section 8.
Yes, my lord, kindly taken up, my lord. Next day, my lord, I shall satisfy you.
Not today.
It's the next week, my lord.
On prayer of the petitioner, the matter affidavit is adjourned. On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 19th April.
I'm grateful. Affidavit service have kept it.
Next.
This matter I am.
This matter, I beg to appear on behalf of the private respondent. I oppose this matter.
What happened? I am the riot holder. In this,
Hearing for the state. Where is your affidavit?
in respect of my,
Have you served the state? Who is your?
yes, ma'am. Again, I have served before mentioning my the data giving.
Mr. Dey, may I request you? Please serve a copy of the repetition to Mr. Dey.
Very innocuous prayer, my lord. What happened? I am the riot holder in respect of my, in front of my riot land, there is a land situation under the irrigation department. The private respondent forcibly encroached the illegally and barricaded my pathway. I am badly suffering for smooth ingress and egress from my riot land. I made representation, page 14, that should be considered in accordance with law. Annex P2.
Yes.
I beg to oppose this PR, my lord. Kindly, my lord, come to his representation first.
Yes.
He mentioned my plot number 173. This is not a government land. This is royalty land. I am handing over my lord, information of the plot. Well, kindly see it.
Well, they will decide.
How it is maintainable? It is not a government land.
Well, irrigation department will decide after given opportunity what the party.
173, kindly see, this is a royalty land. This is 10,000.
Well, let them decide the matter and pass a region order.
Entire land.
Only 0.32, not the entire land.
32.
A portion of the land.
32, my lord, kindly, the ratio.
32 decimals is royalty land.
Total land 32.
What about the remaining part?
No, it is a total land 32. Kindly see. Right hand side top. My share 10,000.
Very well, they will decide.
10,000 is entire share, entire land. No remaining land.
Let the authority decide.
Yes.
Because it's solely the
Particularly,
record of
kindly mention this.
Affidavit of service.
Respondent number 5, it should be better.
It is submitted on behalf of the petitioner. Now, the petitioner claims to be the recorded owner of the plot in question and submits that the private respondents have raised unauthorized construction by encroaching upon a portion of government land adjoining his property, thereby obstructing his residence. The petitioner submitted a representation in this regard before the concerned authority on 16th November 2023, which is yet to be considered. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph. Introducing a copy of the record of rights in respect of DAG number 173, learned counsel for the private respondents submits that the entire plot number 173 belongs to who is Annapurna Maiti?
My settler. Annapurna Maiti settled in our favor. In our favor. We are possessing our, my lord, every records we possess, my lord, the Gram Panchayat.
She is your predecessor.
Yes.
Settler.
Belongs to one Annapurna Maiti who settled the plot in favor of the private respondents. Learned counsel for the state respondents submits that the fifth respondent be directed to consider the representation in accordance with law. Paragraph in view of the above. This court is inclined to hold that since the representation submitted by the petitioner is pending before the authority, the concerned authority being the fifth respondent herein, be directed to consider and dispose of the representation within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, in accordance with law.
Grateful to your lordship.
Paragraph, the parties shall be at liberty to
Chandida.
produce relevant documents in support of their respective claims before the authority at the time of hearing.
I deeply grateful.
Disposed of the judgment. Thank you. None appears for the state respondents.
Next, 686.
अच्छो private तो then हाँ upgradation notice then upgradation अच्छो तो
Your
My lord.
state.
private respond somehow managed
My lord,
the matter has been mentioned.
my lord, it has notice has been served. Oh, Mr. Dhar is there.
Yes.
My lord, the petitioners are the owner in respect of my lord of the 3 decimals of land. My lord, they have constructed residential house there. My lord, the private respondent constructed a my lord shop room. My lord, by obstructing the ingress and ingress of the petitioner over the PWD land. To that, my lord, we made a prayer before the respondent number 3. My lord, let the proceeding be initiated by the respondent number 3. Lordship, kindly consider the representation by 32. So the executive engineer, Tomluk Highway Division.
Assistant engineer.
My lord, he may refer it. My lord,
But kindly come to page 30. Page 30. The next representative.
33, yes. No.
May I read for you, Lord?
This is to the officer in charge.
May I read for you? আমার বিনীত আবেদন এই যে উপর বিনীত বিবাদ আমার রাজনৈতিক জায়গায় গৃহ নির্মাণ করিয়া আমার শালা করিয়া ব্যবসা করিতে উল্লেখ থাকে যে উক্ত দোকানঘরটি এগরা বাজপুর পিচ রাস্তার মালিকানা পিডব্লিউ রোডের অন্তর্ভুক্ত ভাবিয়া আমরা কখনো প্রতিবাদ করি নাই। বর্তমানে সার্ভেয়ার দ্বারা পরিমাপ করে জানিলাম যে রামহরি রানার দোকানঘরটি আমার এবং আমার ভাইয়ের নামিত নামত্ব রেকর্ডভুক্ত জায়গায় রহিয়াছে। উহাকে বারংবার ক্রিয়া যাতে করিলেও কোন রকম কর্ণপাত হইতেছে না। সিভিল ডিসপিউট representation itself we are taking.
my lord, whether it is at all upon the PWD land or not. My lord, if it is, my lord, my learned friend, my lord, my lord, let my learned friend undertake that he has not make any, my lord, construction upon the PWD.
He himself says we initially thought that the shop room was on the PW land, but after demarcation by the surveyor, it come to know that is on our land.
But it is upon the PWD land. Lordship, kindly consider page 32.
আমার হাতে আর কিছু নেই। I have proceeded with
জায়গা সম্মুখে জবরদখল মুক্তি করিবার জন্য কথা কি আছে এটা দেখো।
It is not PWD land.
Manat, kindly see my report. Manat,
Yes.
First page, Manat will find that after receiving the application on 17th August 2023 of Subhashish Parua, the undersigned requested to the BLLRO, Bhagwanpur 1, video office memo number such and such, and thereafter, after this writ petition, the instant writ petition again communicated to the BLLRO. So, my officer has proceeded with the representation. So, let it be logically concluded. That will.
My lord, from page 32, my lord, it is clear, my lord. That, my lord.
32 also says it is recorded in your brother's name and not, it's not
Yes,
government land. So I don't think the repetition can be maintained.
My lord, page 32, my lord, where, my lord, it has been stated that, my lord, that has been made by Subhashish Parua.
Please read the middle part.
Yes. বর্ণিত জবরদখল করিয়া
বর্ণিত
অধিকৃত জায়গা যাহা আমার দাদু রাখালচন্দ্র পড়ুয়ার নামে রেকর্ডভুক্ত ছিল, পরবর্তীকালে ওয়ারিশ ক্রমে আমরা
আমার ও আমার ভাই
ভাইয়ের নামে record লিখতে আছে।
রেকর্ডভুক্ত রইয়াছে
Yes.
বর্তমানে স্থানীয় গ্রাম পঞ্চায়েতের প্রধান অফিস হইতে গৃহ নির্মাণের অনুমোদন পাইয়াছি। আপনি নিম্নবর্ণিত জায়গায় যাহাতে উচ্ছেদ করা হয় তাহার জন্য প্রশাসনিক সহায়তায় আইনানুগভাবে ব্যবস্থা গ্রহণ করিয়া উচ্ছেদ করিয়া আমার গৃহ নির্মাণ করিবার বন্দোবস্ত
So
করি।
that land is recorded in your brother's name.
Recorded in our name, in both the brothers' name.
Yes, so it is not government land or PW land at all. It's a private
Below-
land.
Lord, let it be ascertained whether it is private land or not.
There is no question of ascertaining. Your document says it is your land, not
Below-
PWD land.
My land is there, but the front side of the road, my lord, one, my lord, Goldsmith shop, my lord, is there. My lord, this is on the PWD.
Where is it stated? You have not stated that in your
Lord,
representation at all.
I should be candid enough, it should be clearly stated. But the fact remains, my lord, from the contents of the writ petition, it will also be clear, my lord, I have stated there, this thing. But my lord, it has not been clearly stated.
It is
My lord-
clearly stated that it is your brother, recorded in your brother's name.
My lord, in both the brothers' name. But my lord,
In both the representations, you have stated that.
but my lord, whatever may be, my lord, since my lord, the BLRO, my lord, is proceeding with this matter, let him ascertain and let him file a report to custard the matter.
Advantage of their own.
To custard the matter.
না না ওর জমি মাপছি না
But even my lord, even in the other representation, same allegation.
In the English version also, you say the front side of your land.
Land.
Front side of the land, but this is PWD land. It may be, my lord, the contents, my lord, is not, my lord, properly been clear. But my lord, lordship kindly consider in this question whether, my lord, it is upon the PWD land or not.
Since the government has taken steps pursuant to this representation, let that be concluded. If upon demarcation it is found it is not PWD land, it goes.
But I'm not on the way, lord. But kindly record these also.
আর ওটা যদি পাওয়া যায় রায়তি প্রসিডিংস ড্রপ হয়ে যাবে
Action taken report submitted on behalf of the state respondents is taken on record. Paragraph, the petitioner claims to be the recorded owner of the plot in question, petitioners claim and submits that the private respondent has raised unauthorized construction of a shop by encroaching upon a portion of PWD land adjoining their property, thereby obstructing their egress and ingress. Stop. The petitioners submitted a representation before the concerned authority in this regard on 17th August.
17th
August 2023.
17th August.
And pray for.
হ্যাঁ রে বাবা 17th August
Consider the representation at the earliest. Paragraph. Learned counsel for the state respondents submits that pursuant to the representation submitted by the petitioners, steps have been taken for demarcation of the plot in dispute. Paragraph. Learned counsel for the private respondents submits that it appears from the representations made by the petitioners that the alleged encroachment is on the land which is recorded in the name of the petitioners and is not PWD land. Paragraph. Be that as it may, since BLRO is a party. The block land and land reforms officer, no.
No, madam.
No.
No, BLRO is not a party,
He's
but
acting as a party because I'll give him a direction.
fine.
Since the assistant engineer, comma, Tomluk Highway Subdivision, comma, being the, he is also not a party.
Assistant engineer, PWD roads,
It should be Tomluk Highway Subdivision. You
Hello,
can add both of them.
Norghat division.
আমার রিপোর্টটা দেখো কে অ্যাসিস্ট্যান্ট ইঞ্জিনিয়ার তাকে অ্যাড করো
You can add him also,
মানে
comma, being the 8th respondent hearing, has requested the Block Land and Land Reforms Officer, comma, Bhagwanpur hyphen Roman 1, comma, Purbo Medinipur, comma, being the 9th respondent, either to add korte hobe, hearing, to demarcate the plot in dispute, comma, the 9th respondent be directed to complete the demarcation work upon service of notice to the petitioners and the private respondent and submit a report to that effect before the 8th respondent within 1 month, from date. Stop.
kindly direct both the persons to
Upon service of
upon
notice,
notice.
I've said.
Yes.
Upon
To
receipt of-
cooperate. Kindly direct both the parties to cooperate at the time of demarcation.
The petitioners and the private respondent are directed to cooperate with the authority in such demarcation exercise. Stop. Upon receipt of the demarcation report, comma, in the event encroachment upon PWD land or any portion thereof is found, comma, the 8th respondent be directed to initiate proceedings under Section 10 of the West Bengal Highways Act 1964 and take the proceedings to its logical conclusion within 2 months from the date of receipt of the demarcation report, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioners and the private respondent, comma, in accordance with law. Disposed of which line, on prayer of the petitioners, comma, liberty is granted to implead the assistant engineer, comma, Tomluk Highway Subdivision, comma, Public Works within bracket roads, bracket floors directorate as respondent number 8 and the Block Land and Land Reforms Officer, comma, Bhagwanpur hyphen Roman 1, comma, Purbo Medinipur as respondent number 9 in the writ petition. Paragraph, the cause title of the writ petition be amended accordingly. Paragraph, since these respondents are already represented, service of further notice upon them is dispensed with.
অ্যামেন্ডমেন্টটা করে দিও
Please do the necessary correction. Dispose of which?
Lordship, may I be permitted to mention a matter? It's an original side matter for inclusion, WPO 1501/23. Lordship, the respondents are
Notice,
yes,
mentioning of a notice?
yes. Lordship, the respondent haven't compliance the order dated 25/1/2023. এটা একটুখানি বলুন। The land lordship, due to overgrowth of the bushes, I have mentioned it last week.
Affidavits were called for, isn't it?
Yes. Lordship, kindly fix this matter in a date. They have not submitted any reply copy, or they have not contacted yet till today.
Where is the notice to the other side, to the residents? Notice of mentioning?
Yes. We have served it today.
Next week, yes. Next week, next week. I'll fix it. I'm keeping it next week. Please intimate the other side once again, okay?
Grateful, grateful, Lordship.
Next week.
Any other mentioning? Original side to be mentioned. Item number 1.
In this matter, I am for the petitioner. Yes, matter is appearing at my instant. Your Lordship, the special referee will be filing the report, Your Lordship. So this matter was mentioned in order to.
So the direction was passed, Your Lordship, on by 29th, Your Lordship, the report has to be published. I have circulated the report.
We have received.
We have received.
I have circulated, and may I just file, Your Lordship, the original report?
Your Lordship, only one submission is that the remuneration of the special referee was initially fixed at ₹25,000. That has been paid by us. Your Lordship, kindly fix another remuneration because he should be.
Another 25,000. Was borne by both the parties, isn't it?
No, that was paid by the petitioner only. Initial 25,000 was paid by the petitioner. Order of Your Lordship will find in Your Lordship order of 7th April 2022.
Seventh April.
2022. Your Lordship,
No order
Lordship
on
would
7th
come.
April.
There is an order of 7th April 2022.
That is the appointment of the special referee. The order.
Your Lordship may hand over the copy of the order.
7th April 2022.
Your Lordship would appear at the page number 2 of your the order.
Order to open any.
দিয়ে দিয়েছে
File any 7th April order.
দিয়ে দিয়েছে
চলে গেল।
No.
Yes, has it been assessed? Have you seen the report?
We have not checked it.
Your Lordship, let the report be taken on record and the writ petition be directed to appear in the list in the month of April, any day after 14th of April, as well Your Lordship's lease so permits.
So it was assessed upon consideration of both your submissions.
Yes, Your Lordship.
Yes.
I invited Your Lordship the statement of claim, counter statement. I given the opportunity to adduce evidence. The claimant has adduced evidence. The state of West Bengal chose not to give any evidence. And after considering everything, I have actually taken the rate of the state of West Bengal. I have not taken the rate of the petitioner. Finally, I assessed on the basis of.
So you have seen the report?
Yes, Your Lordship. I have signed the report and it's fine.
No, you've seen it. You have gone through the report.
No, sure, this is my report, Your Lordship.
I am for the petitioner.
I was confused. So have you seen the report?
I have seen the report, but in that case, kindly keep the writ petition, Your Lordship. I have given it to my client also. If any exception is to be taken. After 14th of April.
But I am being very candid. The state has preferred an intercourt appeal, mandamus appeal against the judgment of the special referee.
Against the engagement of the special.
Because the main profit can be for only the limitation for three years. Though the argument was advanced on behalf of both the parties, the state advocate, who was
So, an order on consent.
consent, my lord.
Yes.
But consent cannot confer the, it's just like trying, my lord.
630 days delay, my learned friends appeal.
There are only cases 630 days delay, but there cannot
No,
be
there-
consent. On limitation ground, my lord, there cannot be more than 3 years, my lord.
Besides limitation also, it was a consent order.
Lordship. Both the parties were present.
Report submitted on behalf of the, report submitted by the special referee is taken on record. Copy of the report has been made over to both the parties, to learned counsels for both the parties. Paragraph. The special referee submits that the initial sum of rupees 25,000 has been paid to him by the petitioner as his remuneration. Stop. The petitioner is directed to pay a further sum of rupees 25,000. The special referee. Forthwith. Paragraph, let the matter appear under the it should be under court applications.
Court application.
Under the heading court applications. You're asking for a month's time. 9th May.
9th May, that's to be good.
Your Lordship, I think 9th May will be holiday, Robindo Jayanti, and 8th May.
8 May.
8th May, I think.
8th May is a holiday.
9th May is a Thursday.
8th May is a holiday.
8th May is
9th is Thursday. So,
Thursday when you lost your
original
place.
side matter.
Only one indulgence, Your Lordship. I have certain original records because the parties, Your Lordship, filed their statement of claim, counter statement. There are evidences also. May I be allowed, Your Lordship, to submit it with the Registrar General or before the Court of Law? That direction may be given, otherwise nobody will accept my request.
Yes, because since it is against one of the parties, let it come before the court. On dated আগে করো ওই যেখানে remuneration বললাম না যেখানে report file বললাম taken on record বলেছি তারপরে একটা লাইন করুন on prayer of the special referee liberty is granted to submit all the relevant documents in connection with the assessment before this court by the adjourned date.
Yes, sir. Yes. I'm grateful.
Court applications under Article 226, item number 2.
For the petitioner, my lord.
Yes.
My lord, to recall, this is that matter, my lord, where an arbitrator was sought to be appointed under Section 11 of the 1947 Act. My lord, I'll be very frank and candid, my lord. I'll be relying upon certain orders passed by this court and certain other documents while addressing my lord. So those are not on record. I'll be seeking a leave to form a supplementary affidavit, my lord.
Your lordship, because my lord, the judgment was supposed to take instruction. If your lordship, my lord, can dispose this on the basis of, my lord, a representation that they have given to us, and we will consider the difference.
My lord, I'll have the affidavit affirmed by tomorrow, my lord. Serve a copy upon a learned friend.
Then my lordship wants to proceed in the matter.
Yes, you do not want to.
No, my lord, I'll proceed. I'll proceed.
that.
I'll proceed, my lord.
He
I'll
doesn't
proceed.
rely upon you, upon the.
But after what I've seen the last time around, my lord, consent order appealed against. The last matter, my lord.
That's a different.
So, my lord, now you've got reservations. My lord, be that, my lord.
Whether that will be entertained or not is a different issue altogether.
But, my lord,
Yes.
the matter gets hanging, my lord. It's kept hanging, my lord. If an appeal is filed. Be that as it may, my lord, let me affirm an affidavit. I'll serve a copy upon that, my lord. Friend, my lord. Let us converse next Thursday.
Take time if you could have approached the authority.
Probably not. But let me come back on Thursday. Let me come back on Thursday.
Not, perhaps it may not make more sense because he's asking for an appointment of an arbitrator by the court, which is impermissible. After
Well, let's.
money for the entire.
Well,
No, he's asking for the remaining period.
No,
He has
he's
taken
asking-
money for a certain period of time.
Yes.
So far as I can recall.
Yes, yes.
But that is not.
The orders, my lord, the orders that I'll be placing before my lord are passed by this honorable court in the earlier round of litigation, which shows that these were fresh determinations, my lord. That is the reason I want to bring them on record.
But he is not subject not subject to correction. I am pretty certain, my lord, as it's from record. He, my lord, was he handed over possession, my lord.
Yes.
In January 2023. Till then, my lord, entire compensation has been paid. 2,96,000 plus an additional amount of around 70 lakh. He has enjoyed that money. He says today, I am not happy with the amount.
Yes.
And you appoint an arbitrator.
Yes.
And I am saying, well, that is not permissible. His case is not that he wants an adjudication of compensation of a period which he did not receive compensation.
Well, let him come back with
If he wants it, then the person also liberty to file an appropriate reply to that.
because consideration of his representation will bring him back to the court again. That's his apprehension.
That's my apprehension.
Yes, then will not even also decide on.
On prayer of the petitioner, the petitioners, comma, liberty is granted.
Like the supplement.
Liberty is granted to use a supplementary affidavit annexing relevant documents. Liberty is also granted to the respondents to use a reply to such affidavit if required, comma, if required, stop. 4th April. Let the matter appear under the same heading on 4th April.
I'm so grateful.
But in that meantime, my lord, the reply has to also be exchanged.
If you can.
Yes,
so
my
that
lord.
you don't waste another.
I'll serve it within the course of next week.
I'm grateful, my lord.
For hearing, item number 3.
At the outset, my lord, I expressed my regret on the last Thursday, my lord, I could not be present on time. Your lordship had to rise, but I am sorry for that.
Never.
My lord,
We have heard the petitioners, it is
yes,
your turn.
now it is my turn. My lord, this is an application for appointment of trustee in the eventuality of death of a trustee who died bachelor and who had no son, naturally. Now, madam, the first question I shall take the point of jurisdiction, whether this application is maintainable before this honorable court or it ought to have been filed before the City Civil Court at Calcutta. The my lord, for that, your lordship will kindly take, my lord, section 73 at
This state.
it can be done.
Without, my lord, any indication in the opposition.
It's a question of law. It is a question of law.
The point, my lord, when
It came from the
was
court.
moved before, my lord, exchange of affidavits.
My lord,
See, my lord, the
my
order.
lord, the respondent had no occasion to submit before your lordship. It was also submitted by the petitioner.
Filed an affidavit, I believe.
Yeah, I have filed an affidavit. But in the no, I tell your lordship, in the affidavit, I have not taken the point of jurisdiction. Even then, my lord, since it is a question of law, my lord, I am asking myself whether I can take the point of jurisdiction in the context of the provision in which my land friend has applied. My lord, kindly take section 73.
My lord, kindly have a look at the order dated 30th November 2023. No indication, my lord.
I'm saying there's no, I'm submitting on the basis of the statutory provision. My God. Kindly take section 73. But may I just read out with your lordship? But 73 is an appointment of new trustee on death. This is what exactly the application is before your lordship. Whenever any person appointed a trustee claims or any trustee, either original or substituted, dies or is for a continuous period of 6 months absent from India or leaves India for the purpose of residing abroad, or is declared as insolvent or desires to be discharged from the trust or refuses or becomes, in the opinion of, pausing here, in the opinion of a principal civil court of original jurisdiction, unfit or personally incapable to act in the trust or accepts an concession, so and so, so and so. The question is, my lord, this being an application before your lordship for appointment of a new trustee in case of death of the trustee of one particular group. Now, my lord, this point could have been agitated, ought to have been agitated rather, before the principal court of original jurisdiction. Now, my lord, here is a sharp distinction. My lord, I may be wrong, subject to correction always. But when we come before this honorable court by filing a suit or whatever, we come within the jurisdiction of ordinary original civil jurisdiction. That is one thing. And this principal court of ordinary civil jurisdiction is a different context. Is totally different. But had he had to file a suit for whatever relief under section 16 of the Civil Procedure Code, the suit ought to have been filed before the city court, not before the high court. And the high court, of course, has a pecuniary dimension. When we come within the original civil jurisdiction, it has a pecuniary dimension. In this case, there is no question for any pecuniary dimension. Yet, when the statute has said before the court, principal civil court of original jurisdiction, in my humble submission, it should be city civil court, because that is the principal court in the district of Calcutta.
Does the entire section say so?
My lord?
Does the entire section 73 say that it will be before the principal civil court of original?
Yes, my lord. It starts with whenever a person appointed a trustee, wants to be appointed a trustee in case of a deceased trustee.
Or refuses.
Yes.
Or becomes.
These are all disjunctives. Or everywhere, or is there. These are all disjunctives.
Absolutely. Or refuses or becomes, in the opinion of a principal civil court, unfit or personally incapable.
Yes. In that case, it has to be.
Civil court when the principal civil court opines that the person is unfit or personally incapable.
Yes.
Then only.
Yes.
Section 73.
Yes. I fully agree with the lordship. Then question comes under section 74. Now kindly take section 74. The language is same.
A very interesting point indeed.
My lord, your lordship will decide. My lord, then comes section 74.
Yes.
Yes. Whenever any such vacancy, here the vacancy has arisen, wherever any such vacancy or disqualification occurs, or I am on vacancy only, and it is found impracticable to appoint a new trustee under section 73, the beneficiary may, he is also a beneficiary, the beneficiary may, without instituting a suit, without instituting a suit under section 16 of the Civil Procedure Code, apply by petition to a principal civil court of original jurisdiction for the appointment of a trustee. Number 74 comes into play. This is actually an application under section 74. This is an application under section 74. Now, if one trustee dies and from that particular group, someone wants to be the trustee, then in terms of section 74, he should file an application before the City Civil Court at Calcutta. But as we know that in all the district, the principal judge is nomenclatured as district judge. Here in Kolkata, being a metropolis, City Civil Court does not have any district judge. There is a chief judge, whatever. But the intention of the legislature, in my humble submission, is he should have filed a suit application before that court. Then kindly come to the explanation. Explanation gulo kothay gelo? Explanation gulo kothay gelo? Bodo boita kothay? But in this book, I don't find the explanations are there.
In my book also there is no explanation.
74
74
74
explanation nahi.
Rule ache.
Be that as may. If that be so, your lordship is well aware that intention for the purpose under the Trust Act, the intention of the settler is to be considered. The intention of the settler here is that it should be by rotation. It should be by, and that is the generally governed principle everywhere. If it is by rotation, your lordship will find from a genealogical table submitted by them, that is at page 107 of the petition. Kindly come to page 108. That is relevant. In the middle portion, your lordship will find Lord, from the branch of Govindolal, your lordship will find in the middle portion the name of Joyantolal, who is petitioner before your lordship. Now, my lord, so far as this group is concerned, this Joyantolal in my affidavit I have stated. Now, simultaneously kindly take my affidavit in opposition.
Yes.
Only 2 paragraphs I'll to your lordship, which has been admitted by them. Lord, kindly come to paragraph 10 at page 7 of my affidavit.
Yes.
The petitioner served the trust, the petitioner before your lordship, served the trust as a trustee for 5 years term during the period between 2017 and 2022. We are in 2024, up to 2022 for 5 years he himself was a trustee. Upon the death of Amyunath Sen from the sub-branch of Jawaharlal Sil, the petitioner has come forward with the instant petition in the admitted scenario that they said Amyunath Sen has no male legal heir, inasmuch as the said sub-branch stand abolished in accordance with the provision of the trustee. Now, my lord, he has admitted that in his affidavit in reply in paragraph 10 has been admitted. এটা কি দিলে তো
Yes.
opposition.
it has been admitted.
In the reply they have admitted is this.
Yes.
Reply টা দে ভাই। দর্শককে দেখাতে হবে তো, সঙ্গে রেডি রাখবি তো পাশাপাশি। এটা রিপ্লাই kindly give me. পুরো আলাদা করে রাখিস না, থাকে না। What is I'm sorry, madam. Reply, your lordship will kindly how paragraph 10 has been dealt with. Paragraph 5.
It's a one-liner, paragraph 10 of the reply.
Yes, paragraph that is also missing in my copy. Paragraph 10 of the reply, he has admitted that. Yes, I was there. Now the question, your lordship will kindly take, my lord, my affidavit again. Only 2 paragraphs. Paragraph 12, 11, 12 and 13. In 11 I have said, in view of the death of the said Amyunath Sen, it is only the members of the board of trustees, that was the desire of the settler, board of trustees who is competent to nominate a new trustee in his place as state out of the branch of Govindolal Sil. Admittedly, he is coming from Govindolal's branch. In a meeting of the board of trustees, no individual can claim himself to be nominated as trustee without concurrence of the members of the board. But that is the desire of the settler. I will show from the trustee itself. Then, my lord, paragraph 12. As aforesaid, since the petitioner was in the board during the period between 2017 and 2022, in the event he seeks to be nominated as a replacement of the said Amyunath Sen deceased, the object of the deed of trust would be frustrated inasmuch as there are a number of members of the branch of Govindolal Sil who was never appointed as trustee, and they should be deprived of they would be deprived of the right in terms of the deed of trust. Now, again, if this petitioner before your lordship is again being appointed, then the whatever genealogical table has been given from Govindolal's branch, there are at least 8 to 10 members who are never appointed as trustee. Now, my lord, one cannot, it cannot be a matter of right. One cannot claim, sorry, claim to be a trustee or with the blessings of the court to be nominated as a trustee. Eventualities are there in terms of section 73 and 74 both. Now, when the desire of the settler, that it should be by rotation, then, my lord, the question comes, as to why the petitioner should be alone appointed. Why not the other members from the group of Govindalal by rotation? And that can be decided only in open meeting of the Board of Trustees. They have the right to appear before the Board of Trustees. They can claim individually, they can claim, and the Board of Trustees will decide. But here, he has made that application that as if other than he, because Amyunath Sen has died, because Amyunath Sen has no male legal heir, the line of descendant mentioned in the deed of trust, he is the person to be appointed. It cannot be his matter of right, in my respectful submission. So, my lord, in fact, there is nothing more in the application according to me. Only I shall draw your lordship's attention to two judgments so far as the jurisdiction is concerned. জজ সাহেবের কপি কোনটা? কি এটাই? আমাকে দুটো দিলে দুটোই আমার। এটা তো আমি এটা। Kindly take these two judgments. One is judgment of the Honorable Apex Court. The other is a larger bench judgment of our High Court. এই যে বলে দিচ্ছি ভাই, 2014 ভলিউম 11 SCC 619 প্যারাগ্রাফ 27 আর 28 আমি রেফার করবো। But kindly take only two paragraphs of this judgment, paragraph 27 and 28. Malad Supreme Court judgment. Malad, this is 2014 volume 11 SCC 619.
Paragraphs?
Paragraph 27 and 28. Paragraph 27 is at page 635.
Yes.
May I read out? Sworn on the aforesaid determination, our only understanding to the submissions advanced at the hands of the learned counsel for the appellants would be that as a matter of natural choice, as a matter of suitable choice, as also a matter of more appropriate choice, the controversies raised by the rival party ought to be collectively determined by the district court. By the district court, Thane, and not by the High Court of Bombay, in exercise of its ordinary original civil jurisdiction. In order to supplement the aforesaid contention, the learned counsel for the appellant has depicted to the quantum of filing of similar petitions before the High Court as also before the District Court Thane, and the time likely to be taken for disposal of such matters by the court under reference. There is no statutory provision to our knowledge wherein the determination of jurisdiction is based on such consideration. No such provision was brought to our notice, and so. So, my lord, the District Court Thane here was declared at the principal civil court of original jurisdiction, not the High Court of Bombay as a court of ordinary or original civil jurisdiction. Then question para 28. The question of jurisdiction is a pure question of law and needs to be adjudicated only on the basis of statutory provisions. In view of the deliberations recorded herein above, it may not be wrong to observe that the submissions advanced at the behest of the learned counsel for the appellants on the issue of jurisdiction are submissions without reference to any principle known to law. To the credit of the learned counsel for the appellant, it may, however, be observed that the above consideration may constitute a relevant basis for transfer of proceeding from one court to the other. Before the above consideration can be examined, there would be one precondition, namely that the above consideration would be applied for transfer of a case where statutory provision express or implied do not provide for exercise of a definite choice. Here, Malad, pausing here for a moment, here section 24 prescribes a court of definite choice, ordinary original civil jurisdiction. As a matter of expressing ourselves clearly, it may be stated that inference of the legislative intent from the statutory provision would exclude from the realm of the submissions of the nature relied upon by the land council of the appellant. Similarly, the Honorable Supreme Court has held that the principal court of original civil jurisdiction means the district court. And here, Malad, in my respectful submission, this is the civil court, not before this Honorable. It could be, had there a pecuniary impact. Here, no question of pecuniary income. So that is the court. And then, my lord, the other judgment is a larger bench judgment of our High Court. এটা হ্যাঁ হ্যাঁ এসএসসি জাজমেন্ট ওই দুটো প্যারাগ্রাফ লেখা এটা কি দাদা my lord, in fact this is from India Kanun, but as your lordship knows, my lord, when we rely upon an India Kanun judge reference, my lord, normally the head notes are not there, but my junior has found it from the, my lord, SCC online. This is a judgment. Your lordship will kindly take note.
Can you please give the reference?
Yes, I am giving the reference. Agent 2016 SCC online, Calcutta 1556 is also equivalent to AIR 2016 Calcutta 236.
AIR 2016?
Calcutta 236. Blood, of course, I am not very comfortable with this device. Blood, may I read out from this? Only, blood, this is a larger bench judgment. They went in reference from the division bench of our High Court, decided by 3 honorable judges of our court. Now, my lord, only 2 things I shall draw your lordship's attention. Kindly come to page 24 of the judgment I have handed over to your lordship. Only in the bottom, your lordship will find the page number. Page 24. In conclusion, I am not reading the full text of the judgment. We are therefore, the consideration before the larger bench was, what is the court of or principal court of civil jurisdiction? Court is holding, we are therefore of the view that the court of additional district judge is also the principal civil court in the district, and accept the view taken by the honorable division bench in West Bengal Housing Corporation, so and so. This went in reference before the larger bench, and the judgment of the honorable division bench has been confirmed. Now here, my lord, the same issue was there, whether it should be before the additional district judge or before any other inferior court in the district. The court said, no, additional district judge is also a principal civil judge. And here, my lord, since the chief judge is there, and if chief judge entrusted the matter before any other landed judge of the city civil court, he is empowered to hear this application, not before this honorable court. These are the only 2 things, 2 judgment. And my lord, I shall also, in our affidavit, I have annexed an order, division bench order of our court, of course, of a different group, but the fallacy is there. My lord, that is a judgment. Your lordship will come to page 10 of my affidavit in opposition. It's a division bench judgment of our honorable court. Now, my lord, this is in respect of Brojolal Seal Group. Here it is from Govindolal Shil. Kindly come to page 25. The views of the court. Page 25 of the affidavit.
Yes.
My lord, the second paragraph. If we closely look to the relevant clause and appreciate the conduct of the parties so long as to how they would react to the said clause, we would find the branch of Govindolal would have 4 trustees. Pausing here, this is from branch of Govindolal. 4 trustees by rotation. That is the intention of the settler. According to seniority, the parties decided they would follow the system and accordingly would go on selecting their representative in the board. The present dispute would relate to the 4th trustee, that the trustees were unanimous. He would come from Brojolal branch. Brojolal branch had 8 sub-branches recognized by the decree, so and so, so and so. These are all relating to Brojolal. But the principle, the court has found that the principle, the desire of the settler was from Govindolal, it should follow the line of rotation. If it is the line of rotation is followed, then, my lord, in terms of the genealogical table, there are many other members. And I have stated, categorically stated in the affidavit, that If he is again appointed for another term of 5 years, then of course the others will be deprived. They are also beneficiaries. The beneficiaries are entitled to be a trustee. They will never get the chance. But and although it is in respect of, in the reply, they have stated that this is from Brojulal's group, so this judgment has no manner of application. They have stated it. Yet, my lord, I say, now kindly come to one paragraph, my lord, at page 29. The last but one paragraph, I believe,
Objection.
of my objection. Page 29, second paragraph.
Yes.
We do not appreciate the conduct of the Board of Trustees to appoint trustee from Govindolal group. Both the division benches observed it was for the Brojulal group to select their own trustee. Hence, the appointment of Dipendu by the board was liable to be set as so and so. This is in respect of Brojulal's group again. But the court has said that the Govindalal's group, the manner Govindalal's group wants to be a trustee, that was deprecated by this honorable court. So, in my humble submission, my lord, following these judgments, apart from the point of jurisdiction, even without prejudice to the on the point of jurisdiction, in terms of the deed of trust itself, my lord, the others should get the chance, and that should be decided by the Board of Trustees. My lord, the Board of Trustees, in fact, the Amyanath Sen died sometime, I believe, in March. Thereafter, they have taken a point that the Board of Trustees did not take any steps. But two letters your lordship will find in their petition. In the first letter, he has proposed his name, and the second letter, he is saying that please do not appoint anybody. So the Board of Trustees, in my instruction, is Board of Trustees could not take any step. Today, if your lordship so directs, the Board of Trustees will immediately convene a meeting, and subject to concurrence, even it may so happen that all the members will concur to his appointment. No difficulty. But let there be a meeting of the Board of Trustees within a time frame given by your lordship, and till such time, my lord, there will be no trustee. The vacancy will not be filled up. Your lordship will direct the time frame within which it should be framed up upon concurrence or in terms of the meeting held by the trustees. That is for your lordship to decide. He cannot claim as an individual's right to be appointed trustee for one term, second term, third term, fourth term. It should not be. Rather, it cannot be. It is also not the object or desire of the settler. Similar to my submission, to conclude, my submission would be that apart from the point of your lordship will first decide the point of jurisdiction. Even if your lordship holds that this court had the jurisdiction, then of course the question of rotation will come, and desire of the settler, your lordship has to consider in terms of the trust deed itself.
That's all your submission.
That's all.
In reply,
And manager, no, sorry, I'm sorry. One more point they have taken in the affidavit, that the affidavit affirmed by my client is signed and affirmed by the manager.
Yes.
Who is the manager? That was the question. Now, my lord, the manager has affirmed a competency before this honorable court. My lord, may I hand off only one paragraph your lordship will kindly see. This is the affidavit of competency affirmed on 20th December 2023.
Should be on record.
It should be on record.
দেখুন the affidavit of competency.
বেশি নম্বর পাবি না কিন্তু
এফিডেভিট অফ কম্পিটেন্সি আমাদের দেবে।
চাইছো একটা তোমার দিয়ে দিচ্ছি এই না দেখেন my lord, kindly only if it is not there, my lord, I'll supply your lordship a copy.
Should be there.
It should be there.
এক দু পাত্রই হবে affidavit of competency.
ঠিক আছে, এইটাই জজ সাহেবকে দেখিয়ে দেবো না, আর লাগবে না। But this affidavit of competence is affirmed immediately prior to my lord, affirming the affidavit in opposition.
Has to be. Yes.
Has to be.
নেই ওগুলো না?
ওখানে যদি না থাকে আমারটা জজ সাহেবকে দিয়ে দিন। হ্যাঁ হ্যাঁ হ্যাঁ
No,
admitted.
somehow it's not there.
My lord, your lordship will kindly, lordship got it? Competency affirmed on 20th December 2023. আর এই আমাদের অ্যাফিডেভিটটা কবে অ্যাফার্ম হয়েছে?
Lordship can have a look at my learned friend's copy, my lord. I don't.
December 2023.
December 20th, 2023.
Nonetheless, my lord, my point under section 47 has not been covered by this conference.
Well, this is competencies with regard to affirmation of an affidavit or petition before this honorable court. Well, as I know the High Court rules, well, only one paragraph. First paragraph, your lordship is.
Yes.
Well, I don't have any other copy, my lord. Kindly look into first paragraph. ইন্ডিয়া কানুনটা আছে। এই ইন্ডিয়া কানুন আছে। দেখলে আমি ছুঁড়ে ফেলে দিত। হ্যাঁ নিশ্চয়ই।
Please give me a copy of this.
My lord, for your lordship's record.
Yes, a photocopy.
My lord, may I have a Xerox and immediately my junior will hand up to your lordship. এটা একটা কপি করে দিয়ে দিই রেকর্ডের জন্য। Immediately. My lord, so my lord, immediately prior to affirmation of the affidavit in opposition, my lord, the manager, by virtue of the resolution of the Board of Trustees, was empowered to file this affidavit. So, my lord, he has filed the affidavit. So, that point taken by my land friend does not stand. But other than this, I have no submission. I will only submit. Your lordship will kindly frame a time with a direction upon the Board of Trustees to convene a meeting, have the concurrence of all the trustees and appoint within such time frame. That could not be done in view of the interim order also passed by your lordship. Kindly clarify the order. That's all my submission.
Anything in reply?
Yes. Plenty, madam.
Plenty.
Yes.
Plenty.
I am happy. Plenty. Yes.
Are you
Now, my lord.
today or you want another date?
কি করবো বলতো? এমনি, কারণ এই জাজমেন্টটা জানতে হবে।
Since you said plenty, that's what.
No, my lord, just to indicate, my lord, with regard to the point of jurisdiction, since it has not been taken at the threshold, neither in the affidavit, it's a point, my lord, which has been argued, my lord, at length from the bar, my lord, for the first time. I have to, my lord, take note of, my lord, all the
In
judgment.
that case, of course, my lord, I shall come with at least 2 Supreme Court judgments that on just this point you have just now uttered. But because I did not take it on the threshold, so I have no right to argue this. I shall come.
আরে সেটাতে আগে
There should not be a reply to reply.
আগে সেটা আমি বলি
হ্যাঁ,
যে এটা আপনি নিতে পারবেন না, তারপরে তো
He said that.
Fine.
No, he has not said that. He only wants to reply to your argument.
Let him reply.
If I am correctly, if
Of course,
Let him
of
reply.
course.
Let him reply.
My lord, I'll just try to place, my lord, the point regarding, my lord, the principal civil court of original jurisdiction, what my learned friend have placed, my lord, the Supreme Court judgment. Lordship will see that is of the Arbitration and Conciliation Act. The Arbitration and Conciliation Acts, my lord, considers section 21E in the definition section, which defines, my lord, a principal civil court.
yes.
This is completely, my lord, a different scenario over here. We are over here, my lord, with CPC in comparison with, my lord, the City Civil Courts Act. My learned friend says, my lord, that this has to be filed before the City Civil Courts Act, before the City Civil Code. Now, if your lordship sees, my lord, the City Civil Courts Act, it is inferior to the High Court.
It is.
It is. It is inferior to the High Court. And very rightly pointed out by my learned friend that since this matter doesn't involve any pecuniary aspect, I have a choice, my lord, to approach before this honorable court. My learned friend cannot say that the High Court is not a principal civil court of original jurisdiction. In fact, your lordship, my lord, had raised a query on the last occasion where I've already placed section 2, subsection 4 of the Code of Civil Procedure, which takes into consideration the High Court. And vis-a-vis this, my lord, I'll may not continue on the next date, but just to indicate to your lordship, my lord, section 3, my lord, I only have one copy, my lord, since of the City Civil Codes Act.
Yes.
I'm sorry, my lord, I'm not equipped with another copy, my lord. I was taken up by surprise, my lord, by this point.
The City Civil Code Act was also taken into consideration by
Lordship,
our larger judgment.
kindly have a look, my lord, at section 3, subsection 2.
Yes.
Now, vis-a-vis this, kindly have a look at, my lord, the cost title for once, the address. If very well, I need not show the address. If my learned friend says that it is in City Civil Code, therefore it is, my lord, assumed that it is within the jurisdiction of the High Court. Now, kindly have a look at, my lord, the boundaries of the, in terms of the latest patent.
Well, these are all admitted positions. We cannot do this.
So if my lord, the office of the trustee of the trust is situated, my lord, left hand side down.
Yes, yes.
So if the office of the trust is situated within the boundaries,
there is no bar according.
there is no bar, since it is the principal civil court of original jurisdiction. Vis-a-vis this, my lord, kindly have a look at, my lord, the Supreme Court judgment for once. Paragraph 27 itself. I'm sorry, my lord, paragraph 26. Lordship kindly takes into consideration that the Bombay High Court is also, my lord, a chartered High Court.
Yes.
It also has, my lord, a latest patent, which is almost similar to this. Now kindly have a look, my lord, paragraph 26 of that judgment.
The Supreme Court judgment.
The Supreme Court judgments.
Yes.
Kindly have a look, my lord, at paragraph 26.
26.
In so far as the jurisdiction within district Thane. So this is, my lord, a list, my lord, arising out of Arbitration and Conciliation Act within the district of Thane. So therefore it is held, my lord, in terms of section 42 of the Arbitration and Conciliation Act, that the principal civil court is the district judge of Thane. It has nothing to do with, my lord, our matter. Nothing at all. Completely different, my lord, legal aspect.
So you say that the present case is not within the original territorial jurisdiction of the city court?
I say that in terms of section 74,
Within the original territorial jurisdiction of both the High Court and the city court?
Yes. High Court and City Civil Court have concurrent jurisdiction to such some effect. If I am within, my lord, the High Court, and if my learned friend says that the principal civil court is only the City Civil Court, that is wrong. It cannot be, because the High Court is always superior to the City Civil Court, and the City Civil Court, my lord, was formulated so as to, my lord, clear off the burden of the High Court.
That is not in dispute.
Exactly. And my lord, the other points, my lord, I'll also place a judgment of Honorable Justice Indira Banerjee Division Bench on the next date on the point of jurisdiction. My lord.
Normally,
And my lord, one more thing, my lord, I don't think, my lord, whatever points I have agitated before your lordship recalls, my lord, the Bombay High Court decision. It says, my lord, any contention raised which will have effect, my lord, with regard to evidence, then only the other trustees can come up and say that this application is not maintainable, or your lordship doesn't have the power to decide this application. None of the points raised insofar. He is only harping on the point that it is by rotation, other, my lord, beneficiaries will not get a chance. Perhaps that is far-fetched, for the simple reason, the intention of the trustee was with rotation. What we are assuming is something very far-fetched, which is not reflected, my lord, in the trust deed itself. Why would we, my lord, assume something which is not there?
that is apparent from the genealogical table itself. And my lord,
I'll just,
there
my
should
lord,
not be a chance for reply to reply. There should not be normally. Yet I only submit that the Trust Act does not contemplate any definition of court. In the interpretation clause, section 3 of the Trust Act, court has not been defined. In the larger bench judgment of our High Court, which I have placed before your lordship, there, my lord, the general clauses act has been imported. Where it is silent, the act is silent about jurisdiction, the question will come under general clauses act. We fall under that category. My lord, your lordship will kindly allow 5 minutes time after he makes his submission, if at all your lordship allows me. After,
Since he has not concluded today, I can grant you 5 minutes before his submission, not after.
Yes.
before his,
Reply
okay,
to what you are
okay, kindly give me 5
Reply.
minutes time
There
only.
cannot be a reply to a,
Fine,
never
fine.
ending in that.
No, it will be never ending.
Then it will be a reply to a reply to a
Yes,
reply.
it
So
should not be. It should not be. Next, what are the
election.
5 and 6.
এইটাকালে করতে রাখবো না on 4th April.
4th April. Yes.
It's a Thursday.
4th April.
Heard learned counsels for the parties. Paragraph, let the matter appear under the same heading on 4th April 2020. On sales,
I'm very grateful. I again express my regret for the last occasion.
আমি এই দুটো রাখছি, হ্যাঁ?
Now, সবই তো
I'll be happy the next.
my lord.
Lord, I'll just, my lord.
This is a legal fraternity, my lord. This is a real legal fraternity. Fight in court, outside friend.
That's normal. That should happen.
My lord, not only, my lord, friend outside court, but huge respect, my lord, for the seniors.
No.
Right?
Yes, of course. Of course it is so.
That's our inherent culture, I guess.
Exactly.
My lord. It's a different culture altogether.
Or the judiciary. That's our inherent culture. And that's what we are proud of.
Exactly.
My lord, even if I am age old, whenever I find any senior in any court is standing, I immediately leave the seat. Even today.
That is what we are.
That is what we have learned. This is our culture.
That's exactly what I have said.
This is our
Because
culture.
I follow this every moment.
My lord. My lord.
Great.
Great.